For reasons mentioned in the order, this anticipatory bail application is dismissed.
Item 3.
For reasons mentioned in the order, the petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount with certain conditions.
Obliged.
Bail application, Lord, it was only listed on 20th of December, this month. But just left over. And I pray it may come on Monday.
Monday possible? Third September.
Fine.
Please, your lordship. Lordship, I beg to mention item number. Lordship, here my prayer is, lordship, let the, that this matter be taken up before your lordship's rising today
Item number?
Which matter?
in 59, lordship. If
May-
not reaches in regular course, at least before your lordship's rising.
Unlikely.
Here same?
See,
Is there?
yes.
It is.
Wait, please, your lordship.
If similar prayer comes from other members of the bar, then we may not be able to accommodate.
May it please, your
Yes.
lordship. Item number 62, your lordship, may I pray for upgrading lordship 6 years imprisonment, 6 months already in jail for lordship intermediate quantity lordship. I lordship appeal is admitted.
No upgradation. Today we have this, we will rise early, so no upgradation.
Then lordship, can I fix the date lordship? Otherwise lordship, it has to be reached lordship. Because last day also lordship, it could not reach because of paucity of time.
We'll see how far we can go.
Their prayer lordship, item number 55 of code 25, that may be fixed on hard or
No, if it is not urgent, no mentioning is required.
May I please, your lordship? For listing of an AB lordship on Monday lordship,
When have you filed?
yesterday filed lordship.
Monday, it will be automatically listed. If it does not get listed, then you mention.
May I plead your lordship, regarding item 26 of court number 25, it was last listed on 18/7. Now it has been listed, lordship. Today the court is not on Tuesday or 2 or 3, lordship. Bail hearing, AB, person is seriously ill, no interim is there, lordship. Co-equals has been granted bail, lordship. To second or third, lordship, for bail hearing. Third, deeply obliged. Item 26 of court number 25.
You give him mention memo.
Yes, lordship, I will give them.
May I please, your lordship? My lord, yesterday one matter was mentioned for withdrawal lordship. And unfortunately, the matter has not been listed. We have urgency because the charge sheet has already filed. Because of pendency of this case lordship, we could not file appropriate application before the time. May I pray lordship, it may be taken up at 2 p.m. lordship. Only for withdrawal.
Okay.
Obliged.
May I please, your lordship, I beg to mention for listing, so matter will come up Friday, next Friday.
Listing of what?
Criminal revision regarding maintenance matter.
When have you filed?
Admission stage, my lord.
No, you pray before registry. If it is admission stage.
May I please, your lordship? Lordship, item number 40, I may allow to withdraw my lord. Item 40, 40.
This court,
Bail application 2575.
heard Mr. MU, what is your name?
MU Ahmed.
MU Ahmed, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application. The
Obliged.
prayer is allowed. This bail application is dismissed on withdrawal.
Obliged.
May I
Yes,
please, your lordship? I beg to mention item number 35.
yes.
Lordship, due to some personal difficulty, the leading counsel, Mr. R.B. Fukan, could not attend court. May it be adjourned till Monday, Your Lordship.
Not till Monday. What is your name?
KJ Hazare.
Heard Mr. K.J. Hazarika, learned counsel for the petitioner who seeks an adjournment on the ground that the conducting counsel for the petitioner has some personal difficulty. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed in the next week on a date to be fixed by registry.
May it please, madam, pray for listing of a bail application, madam. Previously, this honorable court had rejected my anticipatory bail application.
When have you filed?
My lord, I have filed it yesterday.
Then it will be listed in its due course. If it does not get listed within 2 days, only then you have to mention.
May I please, your lordship, lordship, item number 50, lordship, and CD is here, lordship. And to no interim, lordship, and he is the manager of the bank, SBI Bank, lordship. So can it be taken to lordship and otherwise?
No,
today
no.
Interim is not there, lordship, bank employee.
Item number?
50. Can it be possible, lordship, and
We will see whether it is possible or not. You have to wait.
others to take court will be rise at 3:50.
No, we will not disturb the list. You wait. Yes,
Obliged,
Yeah, please, your lordship. Lordship, I beg to mention item number 50 of court number 25, lordship. Here in this case, lordship, the petitioner is behind the bar for 46 days. So lordship, kindly, there is urgency, lordship. So kindly this matter
No.
take it. The offense
it
involves.
it is in what stage? And
uh,
hearing, bail hearing
Bail
stage.
hearing. Today fixed for bail hearing.
All if we go by your argument, then all bail hearing would be urgent.
As on today, lordship, 46 days and.
What is the
statutory period
offense?
is Assam Game and Betting Act, lordship. 60 days offense, lordship, mandatory period is.
On
60 days.
Monday,
Monday, lordship.
Monday.
Briefly, your
May I
lordship.
please, your lordship? Your lordship, I beg to mention for listing of a matter, item number 2 of court number 25, your lordship. Can it be listed on 9th of September, your lordship?
Court number?
25, your lordship. But the court is, before today.
9th of September. Okay,
Yeah, please, your lordship. Yeah, please. I beg to mention item number 42, my lord. We have filed additional affidavit, my lord. That may come on record, my lord. Item
bring the additional item.
This bail application was first listed on 22/8, my lord. On that day, due to medical emergency, I could not present, my lord. So it was adjourned, my lord. Kindly, my lord, on Monday, my lord.
What is the matter?
Matter, this is the anticipatory bail application, my lord.
What is the offense?
Offense, my lord, it is also meant, it is registered under section 376. However, it's a prima facie, my lord, it's a false case, my lord. Kindly on Monday.
Third,
Monday, my lord.
no, third.
May it please your lordship. Lordship, I beg to mention item number 45 of code 16. Lordship, we had filed an additional affidavit. The same may be called for.
Court number? This
16,
court,
your lordship.
this court.
Yes, your
Okay,
45. Lordship, another prayer, lordship. In item number 49 of code 16, lordship, the learned counsel is not available today, lordship. He is out of station.
item number?
49, your lordship.
What is your name?
A Ghoshal, your lordship, on behalf of T. Chutia.
Heard Mr. A. Ghoshal, learned counsel for the learned counsel submitting on behalf of Mr. T. Sutia, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. The prayer is allowed. Let this matter be listed on 19th.
Lordship, there is an interim.
The interim order shall continue till next.
Obliged, lordship.
May I please, your lordship? Court number 25, item number 33, lordship. So urgency, dear lordship, please the matter taken up from Monday, lordship.
What urgency?
Urgency, lordship, the anticipatory bail application, lordship.
Okay, on Monday.
Obliged, lordship.
You have to give a mention memo.
Your lordship, I like to mention item, court number 25, my lord, supplementary list 48, my lord. The matter may be Monday, my lord. Bail hearing, my lord.
Give a mention memo.
Please, your lordship, I beg to mention an item for listing anticipatory bail. lordship.
When have you filed?
Yesterday, your lordship, there's some.
Wait for your
Sorry.
turn. If it does not get listed on Monday, only then you have to mention.
Public. Item 4.
May it please, lordship. Lordship, intermediate quantity, NDPS intermediate quantity, city was called for, but city did not come today. And today is 55 days to the lordship. I have the medical emergency, lordship.
What medical emergency?
Lordship, we have the hyponatremia, in paragraph number 6, I have mentioned, lordship. It has been suffering from hyponatremia and acute kidney injury. Hyponatremia, that means low level of sodium lordship in his body, and he was admitted in the Defu Medical College. He has been referred to GLCH, but due to in judicial custody in Defu, that he could not be treated.
Maybe fix on second, my lord, we have sent the signal obviously on 28th of
Heard
August.
Mr. M. Rahman, learned counsel for the petitioner. Also heard Mr. How much was the contraband
47 gram
of
opium.
opium?
Yeah.
Also heard Mr. K.K. Parashar, learned additional public prosecutor, who praised for fixing a short date for production of the case diary. The prayer is allowed.
Second.
Let this matter be listed on second. Learned counsel for the petitioner submits that the petitioner is suffering from certain ailments. The jail superintendent, where he is detained,
Defu jail.
jail superintendent of Defu jail is directed to provide all necessary medical care to the petitioner while he is in custody. List accordingly.
Item 5, obliged.
May I please, lord? Regular bail application, lordship, charge-sheeted matter, lordship. Foxo matter, lordship.
Heard Mr. S.K.
Can copy at
Chetri.
least,
Heard Mr. S.K. Chetri, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the scanned copy of the records of special POXO case number 78/2024. Also issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 by in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 18th of September.
May please, your lordship. Is a petition, bail application under section 483 of BNSS 23, your honor, regarding granting bail of accused Vikram Thakur, your honor. Your lordship, in dispute PS case number 669/25. The present petitioner was arrested on 9/8/25, your lordship. He is already in judicial custody since 21 days. Your lordship, he was a carpenter and was doing his just sitting in a roadside tea stall when he was just some people, police people come and arrested him without any reason, your lordship.
Why your-
Kindly,
Why your prayer was rejected by the?
no, this is it was moved before the learned judicial magistrate, your lordship,
Where is that rejection order?
last page,
page 25.
page 25. Since it is a session type of lordship.
Case diary would be.
146 is there.
Your lordship, just kindly peruse the FIR, your lordship, page 17. There is no allegation, not a single allegation against the present petitioner, your lordship.
Where is your forwarding?
Forwarding is on 18 page, page number 18 and 19. There is nothing against me, simply I am arrested as accused, but no allegation against me, your lordship. In FIR, not a single word against me, your lordship. And in the, even the arrest, grounds of arrest were also not communicated to us, your lordship. Neither to the accused nor to his relatives, your lordship.
When can you produce the case diary?
Dispur, my lord.
This court. We are fixing short date.
Third,
Heard Mr. D.K. Jain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case and release this matter on 3rd of September.
Seven.
May I please go? The regular bail application, Lordship. Petitioner was arrested on 22/7/25, Lordship. As in today, he is been about 39 days, Lordship. Did you maybe call for, Lordship?
Heard Mr. S.K. Chetty. Call for the case and listing, fixing,
My lord, Kiazuli, my lord, 9th, my lord.
9th of September.
May I please, Lordship? But in this case, after ossification tails, the petitioner found juvenile and accordingly he is already granted bail. So this bail petition become infractuous, Lordship.
Heard Mr. K. Raman, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant bail application as the petitioner has already been granted bail on bail by the Juvenile Justice Board,
No, my lord, session judge.
by the session judge.
Well, we have an order downloaded.
Session judge, which district?
Udalguri.
Session judge Udalguri.
It's a special POCSO. Lordship.
Not
Special POCSO judge Udalguri.
special Poxo Judge Udalguri, by order dated 27/8/25.
By order dated 27
8/25.
8/2025. Considering the submissions made by learned counsel, the prayer is allowed. This bail application is dismissed on withdrawal.
My lord, obliged.
May I please, Lordship? Kindly. Kindly look at page number 9, Lordship. The allegation against the present petitioner, Lordship. May I read, Lordship? So and so, Bongaida PS lodged a complaint regarding derogatory remark made on a social media platform, which has hurt the sentiments of people belonging to Hindu community. On so and so about so and so person identified as so and so is the petitioner. Having phone number so and so, resident of so and so, and reportedly a student of Bornover College, Sorbo posted a comment on the platform Instagram from the account number so and so, Ramka Pasbatha. This is the allegation. In fact, Lordship, the mobile number of the phone of the petitioner was hacked by someone. I, Lordship, myself, Lordship, went to the police station to lodge the complaint. And police, Lordship, after going to the to my mobile, I was detained on that very day. In fact, Lordship, I myself went to the police station to lodge the complaint. Again,
Where is the bail rejection order?
yes, Lordship, case 13. All sections are may extend to 3 years, Lordship, and 2 years. Punishment.
Since when you are behind the bar?
11/8, Lordship, 19 days. Lord.
Where is the rejection order?
Yes, 13. Yes, 13. 1/3. My mobile has already ceased.
Yes, Mr. Parashar.
19 days.
Mr. K.
Thank you.
M. Khan, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Baharul Islam, who has been detained behind the bars since 11/8/2025 in connection with Manipur PS case number 95/2025 under section 299/196/352/353 within bracket 2 of BNSS. The gist of accusation in this case is that one Manas Jyoti Saikya, SI of police, had lost an affair before the Manikpur police station on 11/8/2025, inter alia alleging that the petitioner has posted some derogatory remarks towards Lord Sri Rama in the Instagram, which has and same has been done with a deliberate attempt to hurt the religious sentiment. Stop. What is your submission?
My phone was hacked by someone. Accordingly, I went to the police station to lodge the complaint. After verifying the mobile, lordship, I got it.
Where is the statement?
Yes, lordship.
Learned counsel for the
Yes,
petitioner
verify.
has submitted that the petitioner is innocent and his phone was hacked by some unknown person. He also submits that the petitioner on 11/8/2025 himself went to Manikpur police station to make a complaint in this regard and showed his mobile phone to the in charge of the police officer in charge. However, police, after noticing the Instagram post, had seized the mobile phone and also arrested him. Learned counsel for the petitioner submits that as the mobile phone of the petitioner has been seized and as he has been detained behind the bars for last
19 days.
19 days. And as he is ready to cooperate in the investigation, he may be allowed to go on bail. On the other hand, Learned, you have any submission?
My lord, going by his age and the length of detention, my lord. Otherwise,
Stop. On the other hand, Learned additional public prosecutor submits that the mobile phone of the petitioner has already been seized. Stop. I have considered the submissions made by Learned counsel for both sides. Considering the nature of accusation and the fact that the mobile phone of the petitioner has been seized, as well as considering the period of detention undergone by the petitioner, this court is of considered opinion that further custodial detention of the petitioner may not be required if for fair completion of the investigation, if he cooperates in the investigation. For aforesaid reasons, the above named accused person is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of London Chief Judicial Magistrate Bongaigaon with following conditions 1 and 2. This bail application is accordingly disposed of.
Item 10. My pleasure, Lordship. Regular bail application under 483. This is in regards to the accused petitioner who is now currently languishing behind judicial custody for 831 days till date. Till filing of this application, it was 800.
What is the date of your arrest?
7/5/2023. 7th of May 2023. Now, this case is the famous case. The doctor couple, Sangeeta Dutta and her husband, who was accused of torturing their foster children.
Whether trial is going on?
Yes, it is already.
What is the stage of trial?
10 witnesses have already been examined, cross-examined and discharged, out of which 3 vital witnesses, the victims, along with the informant has also been examined. We have annexed it as annexure here. Now, our main ground here is that since already there is sufficient amount of time we had already passed in the judicial custody, the fact that now the only moot question that has to be discussed and has to be answered is whether custodial trial is required or not. So for that particular, we require a CD, and at the same time, we will also the LCR. Let us call for the LCR, my lord.
Heard Mr. W.R. Medhi, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the scan copy of the trial court records as well as scan copy of the case diary of Paltan Bajar PS case number 193/2023 be called for.
Yes, and notice application.
Let also, POXO is there.
Yes, section 6. In the charge frame order now, this accused petitioner has been charged with 326A of IPC, with section 6 of the POXO and other juvenile act.
Who is the respondent number 2?
Respondent number 2 is the Akash Mondal, that is the informant.
Who is he?
He's an advocate who he had lodged an FIR. Like on the day of the incident, he was informed by some Juma Sen through a phone number that such an incident had happened, and then he went and as a social Samaritan, he lodged this FIR.
Otherwise, the accused will be the mother of
To whom notice will go? To the informant. Deepak Naik says that notice should go to the victim, guardian of the victim, or the support person. Whether any support person has been.
As far as our knowledge is concerned, they are still in children, this children home.
Okay, we are issuing notice to the informant. Let the notice be also issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard. Within 3 days from the date of this order, returnable on 16th of September.
Any earlier date? 16th is okay.
Earlier may not be.
Yes,
16th of September.
oblige.
My application, this is a regular bail application, my lord, NDPS case, Sashita's case, my lord, trial is going on, my lord. My lord, kindly call for the scan copy of the trial court records, my lord.
Heard Mr. S. Rahman, learned counsel for the petitioner, also heard Mr. K.K. Parashar. Let the, on what ground you are seeking bail?
My lord, at the time of arrest, my lord, the ground up has not been mentioned in the
Let the
notice. my
scan
lord, that's
copy of the
research.
trial court records as well as scan copy of the connected case diary be called for from the trial court registry to issue requisition for the same. List this matter on 18th of September.
Oh, yes.
Wait, please, Lord. Lord, sir, charge sheet case charges have already been framed. Lord, 65-1 BNS and 6 of POXO. Let me call
Okay,
for the
heard Mr. M. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. What is your ground for seeking bail?
Lord, I have been behind the bar since 5/3/2025, Lord. And the only on based on
Whether
the
charges have been framed
frame. charges are
and
framed.
evidence.
Evidence, evidence of the victim is supposed to be taken within by the next day.
Okay, let also a scan copy of the trial court record be called for. Issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 19th September.
Amen.
Item 13.
Your Lordship, Lordship, kindly matter we pass over for time being.
Okay. It is a under investigation. We are calling for the case diary. What is your name? What is your name?
P. Kakoti.
Heard Miss P. Kakoti, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Call for the case diary. List this matter on 6th of 8th of September. Item 14.
Please, your lordship. It is a charge sheeted case, lordship. POXO is the allegation, lordship, and he was earlier released on bail in 2020, lordship. He appeared in the trial for about 3.5 years.
You defaulted.
Yes, lordship, and NBWA was issued, and thereafter he has been produced in before the learner trial.
When?
My lord,
When?
he was produced in 2025, lordship. He absconded in the year middle of 2024. He actually went to work, lordship, and the evidence of 4 witnesses have been already recorded, including the victim and informant.
Oh, POXO is there.
Lordship.
Okay. Heard Mr. S. Day, learned counsel for the petitioner. Also heard Mr. K. Parashar. Let a status report of the trial be called for from the trial court. Let also notice be issued to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 15/9. List
Much
accordingly. Yes, Miss Mary.
Thank you, Your Lordship. Lordship, regular bail application, Your Lordship. And
21C. This investigation is going on or charge sheet has been filed.
Rejected order is page number 20. Charge sheet number is 2625. The paragraph number 2.
Heard Miss A. Medhi, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Call for the scanned copy of the trial court records as well as scanned copy of the connected case diary. The registry to take steps for requisitioning the scanned copy. Let this matter be listed on 17/9. Item 16.
May it please, your lordship. Lordship, regular verification, lordship. Petitioner is behind the bar for last 79 days, lordship. Earlier, lordship has rejected his prayer for bail, lordship. Offense, lordship, under 420 and 409 of the IPC, lordship. And the allegation, lordship, is that the bank manager of Oriental Bank of Commerce, Tinsukia, has obtained certain original land documents from the complainant. Subsequently, those documents were used in regard to another loan of 50 lakh pertaining to another lordship company. And thereafter, the complainant has lordship
Case diary would be required.
79 days, lordship, and lordship in the meantime, what happened, lord?
We are fixing short date.
In the meantime, what happened, lordship, the petitioner has sought a progress report from the lordship IO, and he has filed a petition in that regard. Lordship, may kindly see page number 33 for a moment. This is dated 7/8/2024. Progress report. Progress, lordship, has IO has lordship furnished that report. Lordship, may kindly see page number 34. The steps taken by the IO.
Yes.
In that regard, Lordship, the bank manager already has obtained the Lordship privilege of pre-arrest bail from this honorable court, Lordship.
Who are you?
I am Lordship Anand Rasiwasia. He is Lordship Amit Kumar Jha. He has obtained the Lordship, granted the privilege of pre-arrest bail, Lordship. Then Lordship may kindly see last part. Now the case is pending for further investigation, and after collecting sufficient evidence, FF will be submitted shortly. So Lordship, at this stage, Lordship, the custodial further detention or intervention, Lordship may not be required, and considering the length of detention also, Lordship. Because the other Lordship investigation has progressed sufficiently, Lordship. Lordship may kindly see, Lordship, that point number 4, Lordship, page 34, serve notice under section 41A CRPC to Sri Amit Kumar Jha, who has been granted the privilege of pre-arrest bail, Lordship, by this honorable court, through registered post during him to appear before the undersigned, but he did not receive the notice and return as unserved. Thereafter, certain Lordship passport officer, he has written the letters. Then Lordship, page 35, point number 6, circle officer also was
Yes,
intimated.
Mr. Parashar.
My lord, by considering the earlier, my lord, considering the case, my lord has rejected, that was the 51 days at the time.
Lordship, 409
Up to the city, maybe.
And Lordship, 409 is not,
If-
409
On
is not.
7/8, I have stated that FF
Yes,
final form
But Lordship,
may be submitted shortly, my lord.
another
In the
thing is that
meantime,
Lordship, 409 is not attracted because I am not a employee of the bank,
may-
or I am a Lordship government. servant.
broker also. may be-
409 is only with
You
regard to
take
public service.
instruction telephonically regarding this status.
Next
Lordship
Wednesday, my
may
lord.
kindly consider one aspect, Lordship. 409 is not at all attracted to me, Lordship. I am not a Lordship banker, not a bank employee,
No,
not a
yes.
public servant. In that case, Lordship, I have already served 60 days, Lordship. 420 at best could come. At best,
Yes.
420 could come.
Last occasion, Lordship, if I remember correctly, this was the case, Lordship, where he absconded from, after taking the loan, he sold off all his property and he was arrested after 4 or 5 years from Meerut, Lordship, UP. He remained absconding.
Oh,
Lordship.
he started a
Yes.
business in
Yes, that is the.
Yes. So Lordship, let the CD come, Lordship.
case diary would be required. We are fixing it shortly.
Otherwise, 409 is not at all attractive.
Heard Mr. N. Hassan, learned counsel for the petitioner. Also heard Mr. A.K. Parashar, learned additional public prosecutor. Let the case diary be called for. When?
Short days, Lordship. Today, 79 days, Lordship. 90 days of it.
Yes.
Fourth.
Putul. 8th.
8th, Lordship, or 88 8 days.
Then you will have a better chance of getting bail.
Lordship. Could it be on 5th, Lordship, or 8th?
Let it be.
Problem.
Yeah, please, Lordship. 376 is there, your lordship may call for CD.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. A.K. Parashar. Call for the case diary. Let this matter be listed on 11th of September.
Item 18.
Item 18. Case 8 is the FIR, your lordship. Case 8.
Yes.
With due respect, back to state that the below noted accused number 1 is my own son. And he is serving as 7 APBN at so-and-so under Kukraja district. After the death of the wife of accused number 1, I am maintaining his daughter Ms. Jyotika Rock IPS for last 2 years. And thereafter the accused number 1 took my granddaughter in his rented house in Bongaigaon for her study. Later on, accused number 1 married accused number 2, who is a mother of a child, and accordingly they are continuing their matrimonial life in a rented house near so-and-so Bongaigaon. But with the instigation of the accused number 2 and 3, the accused number 1 started to cause physical and mental torture on my granddaughter since 3 days back. On the other hand, it has come to know that from local people through social media that she was forcefully made to consume human stool on so-and-so, and hence I lost this FIR. Petitioner number 1 is the son of the informant. Petitioner number 2 is the wife of the petitioner number 1. And 3 is the mother of the petitioner number 2, that means lordship, mother-in-law of the petitioner number 1. My lord, in fact, lordship, the daughter lordship of the petitioner number 1, after her mother died, lordship, petitioner number 1 entered into second marriage, and she was having with one daughter. Both the lordship daughters were playing, and she was got admitted in a Jati Vidyalaya by her father. My lord, what happened? She had a bad habit, lordship. She used to pass her stole on her wearing cloth, and that bad habit, lordship, petitioner number 1, lordship, tried to remove her from that bad habit, but she was maintaining that. And sometimes, lordship, some threatening was given, and sometimes school.
Yes, Mr. Parashar.
But otherwise, as far as this,
The offence is under section 75.
All other sections are available, only 75. Juvenile justice.
by a mother giving this, some lost this FIR, my lord.
He lost this offer based on some
Yes.
social media.
Social media, my lord, may come, my lord, but
Some protection.
mother
will
has
be given,
to
lordship, we
lost
give
this
you.
FIR.
No, the,
The- Any gravity of the offense, my
Oh.
lord.
we are calling for case date. Short date.
Only the other sections are available. BNS sections are available. JGBs may extend to 3 years or 5, or both.
Heard Mr. M. Khan, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Considering the nature of accusation leveled in the FIR against the petitioners, perusal of the case diary would be necessary. Hence, call for the same. List this matter. Give a short date. 8th.
Item 19.
May I please, your lord.
Yes.
This is an anticipatory bail application. First of all, I'd like to draw lordship attention to there are several FIR has been lodged on the same cause of action. The first FIR, lordship, at page 50, my lord. 41, my lord, sorry. This is the first FIR, my lord, lodged regarding, my lord. Basically, all FIR, the same cause of action, the
Page 41.
page 41, my lord. This was registered on 17/6/2004. 24, my lord. Regarding, my lord, the fake appointment, basically, not in the government job, but the allegation of fake appointment. On this basis of this FIR, my lord, we have approached, my lord, this court, my lord. This court has granted privilege of anticipatory bail, that is, my lord, page 47. my lord. Page
Yeah.
47.
Yes.
And my lord, again, there are three more FIRs has been initiated. Then the next one, Lord, you will find at page 50, my lord. Before that, my lord, lordship, kindly turn to, my lord, page 60, my lord. For the same cause of action now, again, one more FIR has been registered. This is in Nunmati, my lord, by one alleged to be the victim.
Where is the FIR?
Page 62, my lord.
62. This is the FIR where you are seeking anticipatory bail.
No, no. Welcome. This is another one more FIR, my lord, where I have been arrested, my lord.
Okay.
Page 62. I've been arrested and immediately I've been granted bail by trial court itself. Page 66. Page 66 is the bail order, my lord. Then I was released on the next day, that is on 11. Then thereafter, one more FIR has been initiated that was pending, that lordship will find at page 70. This is time with Chanmari, madam. This is page 70, my lord.
Yes.
In this case also, I have been granted privilege of interim bail after my arrest, my lord. On the same cause of action, my lord, now these FIR, all these FIR, now these are the FIR, my lord, previous FIRs are filed by the some of the alleged victim. Now, this is the FIR, my lord, where I am now seeking lordship's interference, that is page 50, my lord. This is the general FIR filed by one person on behalf of the all other victim, my lord, the page 50. This starts from, my lord, the content starts from 54.
Yes.
Same content, my lord. By this time, it's a general FIR, first by not by the victim, by one person. In the first paragraph, lordship will find that he has filed on behalf of those person, my lord.
Yes.
Therefore, on behalf of them, I am narrated this story, my lord. He is not a victim. On behalf of some of the victim, he has lost the FIR. Same facts, my lord. The last three FIRs, my lord, where the first one I have granted the privilege of interim, my lord, anticipatory bail. Next one I have arrested, I got the bail on the next day. On the after my arrest, my lord, and they again in the next day have been picked up again. Though this FIR was pending from the long back, it is from the 13/4/2024-25, my lord. They have not arrested, neither shown arrested me, though I was in custody. I'm in custody for 10 days.
Now
10 days.
you are on bail.
Yes, ma'am. In all other cases, when I was in custody in other cases, the police has never sought for my production before the court. In this particular case, though it was pending 13/4/2025. It is in this court. I was arrested once in the Chanmari, once in the Nunmati, madam.
Now what is your submission?
That the malady, Kejari may be called for, I may be protected in this case because on the same allegation, and we again and again, there are several cases are
But
coming
the
up.
victims are different.
No, madam, this is the FIR on behalf of all the victims. This FIR.
Also include those victims for whose behalf earlier FIR were lodged.
Yes. For all victims, there are person specific. Now this is on behalf of everybody. This third FIR, and the content is similar. And when I was in the custody for 10 days, the police has never sought for my.
When you were released on bail?
I was released on bail, one that is on my lord, 21/8 in case of my lord Chanmari, and thereafter Nunmati. I was arrested on 8/8, my lord, and I was released on 21/8. I was arrested on Nunmati PS on 8/8. Sorry, my 10/8. And thereafter again I was arrested in the Chanmari And in afterward, my lord, I have released on 12. 10 days I was in custody. During that period, they have not sought for my custody.
You were released on
On?
21/8
21,
in connection with which case?
Chanmari,
Kanmari PS case number?
203/25. Before that, my lord, one more case, my lord, it is Nunmati PS case. Nunmati also. In both the cases, I was in custody for nearly 10 days.
Yes.
My lord, several cases against this person, other two cases, 2-3 cases by the, my lord, direct victims, my lord. Maybe, my lord, this is the detail FIR, my lord, page 54. And Bharatiya Railway Mal Godam Shramik Sangha, there is no way, my lord, this is a fake union, my lord. And against the specifically, my lord, stated about the petition on page 56. FIR starts from 54, my lord. Page 56, my lord, paragraph number Z.
Lordship will find it's just an photocopy, cyclostyle copy of the Chanmari FIR, where I have been arrested and granted bail.
The main culprit who have been running the scam are the sensor and Dhan Kumar Deka, Northeast Zonal in charge. But the fake
Allegation.
union, malad, they are making the fake union, malad, and malad, they are collecting money not from the Assam, malad, West Bengal and Odisha, these are also, malad, as per the FM, malad. So let the CDP call for at this stage, malad. Anticipatory bill, malad.
My lord, Lordship, my friend which hears just now read from Dispur, my lord, the same content Lordship will find at page 75. Page 75 in the Chanmari FIR. Same, my lord. It's a just and cyclostyle copy of the other FIR, my lord. F.
Okay. Heard Mr. A.M. Bora, learned counsel for the learned senior counsel assisted by Mr. V.A. Chaudhary, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 482 of DNSS has been filed by the petitioner, namely the Dhan Kumar Deka, who is apprehending his arrest in connection with Dispur PS case number 385/2025 under section 61 within bracket 2/318 within bracket 4/316 within bracket 2/336 within bracket 3/340 within bracket 2/240204 of DNS 2023. The gist of accusation in this case is that on 13/4/2025, one Debashish Bora had lodged an FIR before the officer in charge of Dispur police station, inter alia alleging that the petitioner, along with some other co-accused, collected money from various innocent persons on an assurance of giving them jobs in the Indian Railways. It is also alleged that the petitioner, along with the other co-accused, had formed a fake union, namely Bharatiya Rail Mal Godam Shramik Sangha, of which the petitioner is the Northeast Zonal in charge. It is alleged in the affair that the petitioner, along with other co-accused, are involved in a scam in respect of scam of taking cash for jobs, and the money taken by the petitioners and other co-accused is to the tune of rupees 5,000 crores. Learned counsel for the petitioner, learned senior counsel for the petitioner has submitted that the accusation leveled against the petitioners in the affair are not true. He submits that similar accusations were leveled against the petitioner in 3 previous occasions by lodging 3 separate FIRs. And in all the 3 cases, the petitioner has been enlarged on bail. He submits that the instant FIR has been lodged by a person, by the informant, who is in no way related with this case. He claims that he had lodged the FIR on behalf of the victims. However, similar FIRs were earlier lodged. He further submits that when the petitioner was detained, that though the FIR in the instant case was lodged on 13/4/2025, neither the petitioner nor the court were informed regarding pendency of this case while he was detained behind the bars. He submits that on 21/8, the petitioner was granted bail in Nunmati PS case number,
In Chanmari,
in Chanmari PS case number
203.
203/2025 on 21/8/25. And now why are you apprehending arrest?
But this is again the one affair because the other 2 affairs without. when
No,
I
how
was-
you came to know about this affair?
Now they have coming with this affair also, this one affair is
No,
pending, they have
okay.
indicated.
After release of the petitioner on 21/8/2025, the police is searching for him in this case. On the other hand, learned additional public prosecutor submits that perusal of the case diary may be required, as in the instant case, detailed acquisition have been made in the FIR. Stop. Let the case diary be called for. Stop. However, till arrival of the case diary, as in 3 previous cases which are of similar nature, the petitioner has been granted bail,
Regular bill.
regular bail, he is directed to appear before the investigating officer of Paltan Bazar PS case number, Dispur PS case number
Dispur PS case.
385/2025 within a period of 7 days from the date of this order, and cooperate in the investigation. If he does so within the stipulated period of time, in event of his arrest in connection with the above noted case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Let
17
this case be listed on
17-9.
17-9.
Appellate.
20.
Please, Your Lordship. Section 18 of the POCSO Act is there, Lord.
18,
18, Lordship.
notice will go.
Notice will go. Only prayer is that, Lordship, here two cases are there, one from our side and another from their side. This is out of purely a civil dispute. So may I pray for calling of both the case diaries, Lordship?
No other, you have lodged an FIR against whom?
Against the father of the victim, Lordship.
You have made statements.
I have annexed that FIR also.
Then that case diary may not be necessary now.
Yes.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. Call for the case diary of Karimganj PS case number
363, my lord.
363 of
25.
25 and issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 19
May
September.
I pray for a short date? 14, 15.
17 September.
Highly applies.
This is for a limited period or transit interim bail. Okay? We have received a notice on 35/3 from the Mumbai police for our appearance. And I have annexed this notice on page 12 and page 14 regarding cyber again. We have been appeared due to financial constraint, we could not appear on that day, and we have received the notice only on WhatsApp. Hard copy of the notice were not served on us. On the last day, we have received the notices. We are ready to cooperate with the IO, we are ready to go there, but for financial constraints, we could not. So we need protection till our for a limited period. I have downloaded the FIR. I could the total amount. As mentioned in the FIR, what it is in Marathi. But so for total amount as space 5 lots, it is 4.5 lakhs only. So for the business firm is concerned, the accused is concerned, it has been, what I could understand is 1.5 lakhs has been transferred in his account only.
Why you cannot go to the
We have
jurisdiction?
received on the WhatsApp notice only on the WhatsApp only on the last day. Then due to financial constraints, Lordship, we are unable to go. We are having no connection with Mumbai. So we are in searching for some connection. Lordship.
Yes,
So
Mr.
interim
Sharma.
protection. We are ready to go there, Lordship.
Should this annexure,
In Priya Indoria case is there, Lordship.
when he lordship the notices were sent.
Annexure 2.
Yes, and page 13 lordship, can you see annexure 2?
No, that is gone. Lordship. I have taken up the printout of the portals. It has not been served. One has returned, one is not paid.
Okay.
We have received this only on WhatsApp. I have made a statement on
You
that.
have the copy of Priya Indoria. Okay, not required. Why you cannot go to Mumbai?
No, we are ready to go. Lordship. But
Then you
due to
go there.
financial constraints, we need some protection, that much only. Lordship. That immediately we will land there, we will maybe arrested. So we will maybe deprived from our liberty, from taking legal consultants, from moving the jurisdictional courts, Lordship.
Yes, Mr. Sharma.
Lordship, first thing, Lordship, the date was 28/7. They have not shown the reason why they
I have mentioned.
approached your Lordship prior to that. And second is, Lordship, the apprehension. Where is the apprehension? Lordship?
Yes, because this is notice under section 35(3). So it is issued only when there is police thinks
But
that,
these are non-bailable offenses. There is in every apprehension that once we land there, we may be apprehended. That's why we want a protection that we may move the
That may
territorial
not be enough.
jurisdictional courts, Lordship. We need some time to appear there, move the jurisdictional courts, Lordship. And for that, transitive, a prior injury judgment and one allowance.
heard Mr. S.K. Poddar, learned counsel for the petitioner. Also heard Mr. D. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Babul Hussain, who is seeking interim transit bail in connection with Navagahar PS FIR number 279/2025 under section 319 within bracket 2/318 within bracket 4/336 within bracket 2/336 within bracket 3/336 within bracket 4/340 within bracket 2/338 within bracket 338/3 within bracket 5 of BNS, read with section 66C and 66D of the Information Technology Act. Learned counsel for the petitioner has submitted that the petitioner is a resident of Morigaon district, and he had received a notice under section 35(3), 35 within bracket 3 of the BNSS from the SI of Police of Navagar Police Station, Mumbai, in connection with the aforementioned PS case. Learned counsel for the petitioner submits that the petitioner had not received the notice through post, and he has only received the notice on its WhatsApp message. He submits that the date of appearance mentioned in the said notice was when you had
28/7, Lordship.
28/7, which has lapsed, and therefore the petitioner apprehends that now if he appears without any protection before the said police station, he may be arrested. Learned counsel for the petitioner submits that petitioner is ready to cooperate in the investigation. However, he could not go to Mumbai due to some financial constraint. He is now ready to go to the said Navagraha police station. However, as he apprehends that he may be arrested, he needs interim protection during transit so that he is able to seek appropriate remedy before the jurisdictional courts. So, learned counsel for the petitioner has cited a ruling of the apex court in the case of Priya Indoria versus State of Karnataka, reported in 2024 4S SCC 749, in support of his submission that in such cases, transit anticipatory bail may be granted for limited period of time. Stop. On the other hand, learned additional public prosecutor has submitted that as the police has issued notice under section 35(3), which itself indicates that it do not intend to arrest the petitioner. Hence, there is no apprehension of getting the petitioner getting arrested. I have considered the submissions made by learned counsel for both sides. Stop. Though normally a presumption may be, normally it may be presumed that when police issues notice under 35(3), the person to whom the notice has been issued is not required to be arrested. However, in this case, as the date of appearance mentioned in the notice has lapsed, the apprehension of the petitioner appears to be genuine, as the offense involved, as the police station case in which he has been asked to appear also involves non-bailable offense. The cause shown by the petitioner regarding his inability to move the jurisdictional court within time is accepted, and this court is of considered opinion that as per the guidelines issued by the apex court in the case of Priya Indoria versus State of Karnataka, this is a fit case where transit anticipatory bail may be granted. So in view of above, the petitioner is granted interim bail till how much time?
Minimum 30 days loss, 30 to 45 days loss. Because you have to have the
Already
tickets
lordship,
also, train
20
tickets.
From 28/7 lordship, now they have approached your lordship, let it be 15 days. Lordship.
No, we have to get the train tickets also, lordship. That is our hurdle,
Train
because it
tickets
is
also
48 hours journey.
In Tatkal lordship, it
We
can
have-
be
Tatkal is not simple, lordship. So give us at least minimum 30 days time, definitely we will appear, lordship. With intimation, we have got the phone number also,
Suggested
we'll inform the IO. Before that, we have
till
to move the
30,
courts also, lordship. Jurisdictional courts,
till 30 September. Till 30 September.
lordship, oblige.
If the petitioner is arrested in connection with the aforesaid case within this period, he shall be granted interim bail by the arresting authority, subject to the condition that the petitioner, subject to following conditions, number 1 and number 2. This interim transit bail shall be operative only till 30 September.
Oblige.
till his appearance before the concerned court lordship or the IO.
No, only till 30 September. If he fails to appear, it will lapse.
Now, if he appears before the IO lordship, then lordship, if they have reasons to arrest him lordship, then they may not be able to arrest him lordship. Let it be till his appearance before the IO lordship, on whichever date he appears lordship.
Maybe, lordship maybe.
Till 30 September or
The date of
or till
appearing before the IO.
till his appearance before the investigating
Which one is
officer
that?
of the aforesaid case, whichever is earlier. This anticipatory bail application is accordingly disposed of.
Oblige.
May I please? Similar application, my lord. First, I would like to draw lordship attention to the FIR, my lord, at page 12.
Transit bail also.
Oh, no, not like that, my lord. On 15th, I received the notice, my lord, 35 notice. I was directed to appear on 17 at Udalguri. Notice was served me at Sibsagar, my lord. I could not appear, my lord, because of the time, my lord. And Lordship may kindly have a look at the FIR. It was lodged in the year 2023, my lord. There was a banking transaction, my lord. At page 12, my lord.
You received 35-3 notice.
Yes, 35 notice, my lord, on 15th. And 15th,
Where is that
15th of
notice?
August, my lord. So, my lord, from Sibsagar to Udalguri, my lord, I could not appear. On
Where is
time.
that notice?
15, page 15. Page 15 is the notice, my lord. It was a WT message to my local police station, my lord. It was sent on 13/8 and I was served on 15/8 in the evening, my lord.
And when you were asked to appear,
On 17, my lord.
why you could not appear?
Because, my lord, 15th, normally, my lord, our side, my lord, all buses were reserved, my lord, all these things.
Lordship will kindly peruse the FIR. Lordship is perused there.
Yes.
Lordship will see just the allegation, Lordship. I would like to bring to your knowledge that a person namely Vivek Pradhan is the present petitioner, contact number so and so, presently residing at Hangrabari, Guwahati. Lordship has seen there. Has convinced me that he will help me in getting a loan of 8 lakhs from so and so, but later Vivek Pradhan told me that my loan of 3 lakhs was sanctioned at SBI Rauta branch to Dalguri. After that, I along with so and so, dated so and so, after going to the formalities of the bank about 4 p.m., the loan of 3 lakhs credited to my account, so and so. After that, Lordship, Vivek Pradhan, without my knowledge, prior permission and information, has transferred a sum of 1,60,000 to his bank account. So, Lordship,
That is quite impossible, my lord.
How he can tell?
Yes, how he can transfer that. And one more interesting thing, Lordship, you'll see his address is shown as Hangrabari. Here also in the petition, Lordship, his address is Sibsagar, different.
Yes, no, my lord.
And
Can you see the
FIR
notice, my lord?
let me finish,
Don't
please.
interrupt.
Yes.
And this FIR was lodged in Lordship the year 2023. For some reason, Lordship, there is a delay, Lordship, because he was not found in his location, Lordship, in his address that was given in the FIR. So probably now, Lordship, when he has been found, Lordship, this notice has been served, Lordship. So I am praying, Lordship, let the CD come, Lordship. How he could transfer amount from another account to his account, Lordship. That needs to be seen, Lordship. So prima facie, Lordship, that has to be seen, Lordship.
But let him appear.
I'm always ready.
Something, because police is also,
Lordship is well aware, Lordship, if once he appears, Lordship, it becomes a different question of law, Lordship, then. Because after appearance, Lordship, it becomes that much difficult to convince your Lordship.
At
no,
page
if the custodial interrogation is not necessary.
Lordship. No, prima facie, Lordship, he
Let-
has to show
let-
some grounds, Lordship, why he is entitled
Okay,
to
I'll
admissible
call him
relief.
for the case diary.
my lord, in the meantime, my lord, may I play Lordship? Pray Lordship at
Heard.
page 4, my lord.
Heard Mr. M. Fukon, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner, namely Vivek Pradhan, who is apprehending his arrest in connection with Rauta PS case number 167/2023. The gist of accusation in this case is that on 8/6/2024, one, who lost the affair?
Just lodged by Lordship on
One Lukumani
Lukumani,
Bora, my lord.
one Lukumani Bora had lodged an affair before the officer in charge of Rauta police station, inter alia alleging that the present petitioner had asked, had told the informant that he would help him in getting rupees 8 lakhs as loan from SBI Trader Branch Guwahati. However, later on, the petitioner informed him that only 3 lakhs, rupees 3 lakhs has been sanctioned as loan. So it is alleged in the FIR that after sanctioning of the aforesaid loan, without permission of and information of the informant, a sum of rupees 1,60,000 was transferred from his bank account by the petitioner. Stop. Learned counsel for the petitioner has submitted that the accusation made in the FIR are not true. He further submits that he had received a notice under section 35(3) of the BNSS on 15/8/2025, asking him to appear before the officer in charge of Rauta Police Station on 17/8/2025. However, as due to some difficulty, he could not appear on that said date. He now apprehends that if he appears before the court, before the investigating officer, now after lapse of the date mentioned in the notice, he may be arrested in connection with this case. He further submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that the accusation level against the petitioner is serious, as he had transferred money from the account of the informant, which is normally not possible. Hence, he prays for calling of the case diary. Let the case diary be called for. Stop. Let this case be listed on 23rd of September. Stop. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Rauta PS case number 167/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with the aforesaid case, he shall be granted interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Number 1 and number 2, list accordingly.
Much.
Yes.
May I please have it? So this was the complaint case lodged before the CCM Morigaon, then it was subsequently forwarded. Lordship. Case 9 is the translated copy, Lordship. Entire allegation is that the petitioner took money in the name of investment in a Min Mahal, Lordship. And now they are not giving the share and threatening, Lordship. Petitioners are neither the settlement holder of that very Min Mahal. I have annexed the settlement order also, Lordship. The entire dispute is civil in nature, Lordship.
You took money.
Both of them, allegation is that they took money to invest in the Min Mahal, Lordship. And now they are not giving the share and threatening, Lordship. They are not the settlement holder, Lordship. I have annexed the settlement order also, Lordship. One Vishnulal Das, he is the settlement holder. And it is also mentioned in the complaint, Lordship.
So your submission is that you have not taken money.
Not, Lordship. Vishnulal Das taken. He is the settlement holder. But they have dragged me, and this more so as civil nature, we may be allowed to, Lordship, record our statement, Lordship, in the interpretation.
I heard Mr.
MK
M.K. Hussain, learned counsel for the petitioner, Also heard Mr. B. Sharma, an additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioners, namely Jatindra Das, number 2, Abu Bakr alias Abu Bakr Siddiq, who are apprehending their arrest in connection with Jagirot PS case number 204/2025 under section 318 within bracket 4/316 within bracket 2/115 within bracket 2/351 within bracket 2/3 within bracket 5 of BNS. The gist of accusation in this case is that one Abdul Jalil had lodged a complaint before the Court of Learned Chief Judicial Magistrate Morigao, naming against the present petitioner, inter alia alleging that the petitioner number 2 took an amount of rupees 3,85,000 from the complainant for investing the same in Haria Dablong Meen Mahal. Meen Mahal. However, it is alleged that thereafter the petitioners refused to return back the said money. And they have misappropriated the money of the complainant. Stop. The said complaint petition was forwarded to the officer in charge of Jagirot Police Station by the court for registration of the FIR and investigation, and accordingly Jagirot PS case number 204/2025 has been registered. Learned counsel for the petitioner has submitted that the present petitioners are not the settlement holder of Arya Dablong Meen Mahal, and one Vishnulal Das has been given settlement of the said Meen Mahal for 7 years by the government, and therefore he submits that the accusations leveled against the petitioners are not true. He further submits that the dispute in this case is predominantly in the nature of civil dispute, and therefore and the petitioners are ready to cooperate in the investigation, and therefore their custodial interrogation may not be necessary. He therefore prays that petitioners may be allowed to go on anticipatory bail. On the other hand, learned additional public prosecutor submits that considering the nature of accusation, the case diary may be called for. Let the case diary be called for. Let this case be listed again on 22nd of August. However, in the meanwhile, considering the nature of accusation as well as submissions made by learned counsel for the petitioner, as discussed in the foregoing paragraph, both the above named petitioners are directed to appear before the investigating officer of Jagirot PS case number 204/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on in interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following condition. Number one. and number
Is there a date maybe 22nd of September instead of August, Lordship?
22nd September.
Okay.
Next according.
May I
Yeah.
please, your Lordship? Well, the petitioner is a married lady, my lord. Well, the affair is page 9. Informant, my lord, stated in the affair that the informant and the present petitioner and her husband, there were two person named in the affair, they are husband and wife. And wife before your lordship. He stated that he has a gym center and they're both introduced, my lord. And in the name of third grade job of ADR, the present petitioner and her husband.
What is ADRE?
Well, ADR, I have not find out. The affair is said mentioned, short form mentioned here. And taken 7 lakh rupees to give the job, my lord. In fact, job is not giving. Now, my lord, money also not returned. Thereafter 2 lakhs returned. And remaining 5 lakhs not returned. Hence the case, man. Well, the fact is that the petitioner, the informant very tactfully lodged this FIR, suppressed the entire matter. The present informant is my lord, professional money lender, my lord. Because nowadays money lender is prohibited, my lord. And my lord, due to some financial crisis, my lord, the husband of the present petitioner took my lord 2 lakh rupees and give to check, my lord. And my lord, 10% high interest, man. And interest was giving since more than 1 year. And when, my lord, the present petitioner husband, my lord, proposed him that you return the check, I will return the capital money. Then he took the 2 lakhs rupees and check is not returned. He is saying some more money I have to pay. And regarding that, my lord, there is a dispute between both parties, my lord. Now, my lord, he cannot disclose the original fact. He's saying this way that in the name of job, they have taken the money. Money is not returned. My humble submission, my lord, that in fact, case is totally false. Even then, we presume it is not a case because a person participating in an illegal contract and when he cannot gain, my lord, he cannot come to the court of law. Because both, my lord, saying that I gave in the name of job, my lord, it's very unfortunate. My lord, if suppose
No, he
it is
can
true.
come to the court of law, accusing you.
Therefore, I am submitting, my lord, that a person, how can say in the name of job, I provided 7 lakh, now job is not provided, hence the case. Suppose he would have been get the job, he did not disclose it. My lord, in fact, they are not a person to provide job, very simple person. Very unfortunate. The money lender is nowadays prohibited, my lord. So my humble submission, my lord, I am a lady, my lord, and money was taken my husband, my lord, as interest, my lord. So at least, my lord, interim may be provided, my lord, the case diary will reveal, my lord. It already, we did not get the opportunity to disclose the fact to the police, my lord. We have
Okay.
the proof, my lord.
Yes, Mr. Heard Mr. B. Sharma. Heard Mr. N. Uddin, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, Srimati Queen Kolita, alias Queen Das, who is apprehending her arrest in connection with Patshala PS case number 72/2025 under section 3 within bracket 5 /308 within bracket 2 /316 within bracket 2 /318 within bracket 2 of BNS. The gist of accusation in this case is that on 11/8/2025, one Dibbojyoti Malakar had lodged an FIR before the officer in charge of Patshala police station, naming 2 accused persons, including the present petitioner, therein, inter alia, alleging that the petitioner and her husband induced the informant to give rupees 7 lakhs to them on the promise that they would provide the informant a grade 3 job in ADRE. However, and accordingly, the informant paid 7 lakhs to them. Stop. However, it is alleged that after taking the money, the petitioner and her husband neither returned back returned back only 2 lakhs, and remaining 5 lakhs have not yet been returned. Neither they offered any job to the petitioner, job to the informant. Stop. Learned counsel for the petitioner has submitted that the accusation level in the FIR are not true. He submits that in fact the informant is a money lender from whom the husband of the petitioner took a loan of rupees 2 lakhs. And at the time of taking loan, he also submitted 2 blank checks to the informant. It is submitted by learned counsel for the petitioner that now the informant is demanding more money in lieu of returning the checks. And when the petitioner and her husband refuse to succumb to his pressure, a false case has been lodged. Learned counsel for the petitioner has submitted that the petitioner, being a lady and not directly involved in the alleged offense, is ready to cooperate in the investigation, and hence she may be allowed to go on bail. On the other hand, learned additional public prosecutor submits that considering the nature of acquisition, perusal of the case diary may be necessary. Let the case diary be called for. Let this case be listed again on 22nd of September. In the meanwhile, however, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, the petitioner is directed to appear before the investigating officer of Patshala PS case number 72/2025 within 7 days from the date of this order and cooperate in the investigation. If she does so within the stipulated period of time, in the event of her arrest in connection with the above mentioned case, she shall be allowed to go on bail of rupees 30,000, interim bail of rupees 30,000 with one surety of like amount, subject to following conditions. List accordingly. Subject to satisfaction of the arresting authority with
My pleasure, Lordship. An application under section 482, Lordship.
item number.
FIR page 10, Your Lordship. A vehicle was parked near the Nehru Stadium. 16 numbers of kettles were carrying by the driver of the vehicle. The driver could not produce any valid documents, Your Lordship. Petitioner is the owner of the kettle. I have annexed the receipt of the kettle, Your Lordship. From page number 12, Your Lordship. The Salan of the kettle, Your Lordship.
Why it was not with the driver? Why driver failed to show the receipts when he was carrying the kettles?
photocopy with the driver lordship, but photocopy was with the driver lordship,
Okay,
but the police personnel did not accept the same lordship.
yes,
Also will kindly come to page 20, annexure 3.
page 20,
Yes, annexure 3,
20,
20.
yes.
Paragraph number 4, Lordship. Just one point I'm like to place, Lordship. The facts of the case in brief are dated on 1/8/25 and FI was lodged by so and so at the Poltonburg PS, stating hearing that 31/7/25 and information was received regarding transportation of cattle in a vehicle to B Burwa Road. Accordingly, a team of police officials, including the informant, intercepted a Richard truck without registration plate. So and so, the driver Abdul Ali was also present in the truck. 16 numbers of bulls were found loaded in the truck. The cattle were being tied with rope and with no other footbands. The driver could not produce any valid documents, so and so. Next, Lordship will kindly come to paragraph 8. Next page, page 22. 22, Lordship will find paragraph 8. Perusal of the case that reveals that although the accused petitioner has not taken the plea that the cattle were being transported to a registered cattle market at Morigaon, no such permit for transportation was obtained from the competent authority as required under Rule 6 of Assam Cattle Preservation Rules 22. The record also reveals that 3 numbers of cattle died during transportation, which indicates that the cattle were being transported in a cruel and atrocious manner in violation of the so and so.
Case diary would be needed. Your prayer for anticipatory bail was rejected after perusal of the case diary. Therefore, case diary shall have to be perused.
Required under Rule 6 of the Assam Cattle Preservation Rule, that was not, this is correct, Lordship. This was not with the petitioner, Lordship. And slaughtering slaughtering of the cattle is not regulated by law, Lordship. Slaughtering purpose, he did not know the cattle were slaughtering or not, Lordship.
We are not into slaughtering.
The petitioner sent to the market of the registered market of Morigaon, Lordship. Earlier petition I have also stated, but learned
Short days.
session that
No, we are calling for
did
the
not
case.
disclose, Lordship.
We are. Harusha. Mr. S. Mr. S. Rahman, learned counsel for the petitioner. Also, Mr. B. Sharma, learned additional public prosecutor. As in this case, it appears that the Court of Learned Additional Session Judge Nagaon has had once rejected the prayer for anticipatory bail of the petitioner after perusal of the case diary. Hence, this court deems it necessary to peruse the case diary before considering the instant anticipatory bail application. Hence, call for the same. Let this matter be listed on 10th.
And Dimma petition was pending, you Lordship, before the learned Elaka Magistrate. And court of 7 Lordship.
8th.
Item 26. May I please, Your Lordship? So the PRS bail application now, page 9 is the affair cancelled process. May I read, my lord?
Yes.
Respectfully begs to state that house of the accused number 3 and 4 located at nearby my house. The accused number 1 always used to visit the house of the accused number 3 and used to entice my minor daughter, namely so and so, aged about 16 years, 6 months, in various ways. In this regard, I have given Bisar to the accused number 2, 3, and 4. The accused now till that he is in lawful custody. And present petitioners are the my lord. Petitioner number 1 is the father of the accused number 1. 2 is the brother-in-law, sister's husband, and 3 is the elder sister. These present 3 petitioners, my lord, nothing role in this case, my lord. And there is admittedly relationship going on between the 2 minors. Victim also minor, accused number 1 is also minor. And admittedly, the parents of the accused, my lord, level-based tried to stay away from the victim girl to of his son, my lord. But again and again, they are voluntarily eloped with each other
without consent of the respective guardian, my lord. And in this regard, my lord, yes, admittedly, the victim, parents of the victim girl given to Bisar to us, my lord. And we are trying to level best to stay from. My lord, in this stage, my lord, I am trying to submit, my lord, against the present petitioners, nothing, my lord. So they are maybe allowed to go on interim bail, my lord.
Yes,
The entire allegation is against accused number one.
one,
Yes, my lord. Who is already apprehended?
heard
Okay, Azam.
Mr. A.K. Azad, London, counsel for the petitioners. Also heard Mr. B. Sharma, London, additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners, namely Mughal Ali, number 2, Fulchan Ali, alias Fulchan Bacha, number 3, Mamta Khatun, alias Mumtaj Begum, who are apprehending their arrest in connection with Kolgosia PS case number 105/2025 under section 140 within bracket 3/3 within bracket 5 of BNS. The gist of accusation in this case is that the father of the victim girl had on 19/8/2025, lodged an FIR before the officer in charge of Kolgosia police station, inter alia, alleging that the accused number 1 named in the FIR, namely one Rokibul Islam, had enticed the minor daughter of the informant, and on 11/6/2025, in the absence of the family members of the informant, kidnapped her and took her to Gwalpara with the help of petitioner number 2 and 3. It is also alleged in the FIR that thereafter petitioner number 3 took back the victim girl to the house of the informant. It is also alleged that it is also alleged in the affair that the informant has lodged a complaint within bracket Bisar. However, nothing has been done in the said Bisar. Stop. Learned counsel for the petitioner has submitted that the petitioners are no way involved in the offense alleged in the FIR, and main allegations are leveled against the accused number 1 in the FIR. And the petitioner number 1 in this case is the father of the accused number 1, and petitioner number 2 is the brother-in-law, as well as petitioner number 3 is the elder sister of the accused number 1. So he submits that the accused number 1 has already been arrested, and because he was juvenile at the date of his arrest, he was produced before the Juvenile Justice Board. Learned counsel for the petitioner submits that it was the petitioner number 3 who, after coming to know about kidnapping of the victim girl, took back the victim girl to her house. So it is submitted that all the petitioners are ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that on perusal of the FIR and the materials annexed along with the bail application, it appears that main accusation has been leveled against the petitioner accused number one, that is Rokibul Islam. I have considered the submissions made by learned counsel for both sides. It appears that the main accusation in this case is against one Rokibul Islam, who has been named as accused number one in the FIR. And it also appears that it was the petitioner number three who took back the informant to her house, to her home. Stop. Considering the materials available in the record, this court is of opinion that if the petitioners cooperate in the investigation, their custodial interrogation may not be necessary for fair completion of the investigation of Colgasia PS case number 105/2025. Hence, this case, this anticipatory bail application is disposed of with a direction to all the three petitioners to appear before the investigating officer of Colgasia PS case number 105/2025 within a period of 7 days from the date of this order.
But
And
one accused is out of station as on today.
within
15
a
days
period
only.
of 10 days.
10 days only.
10 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with the aforesaid case, they shall be allowed to go on bail of one surety of like amount. Bail of 30,000 each with one surety of like amount, subject to following conditions, number 1 and number 2. This anticipatory bail application is accordingly disposed.
Mas-
27.
My lord, the chief editor of Daily Agradut newspaper, my lord, lodged a complaint before the Deputy Commissioner of Police Central, alleging that some Afghan nationals who have come to Guwahati and involved in the business of interest in various places without having any valid documents. This is the main allegation. And the second allegation is that they have entered in India with some fraud documents and thereafter they obtain passport, Aadhaar card, voter card, PAN card, etc., etc. And he has stated regarding 3 persons, and out of 3, 1 was arrested. And therefore, he sought my lord investigation how they have obtained all those documents. And the main allegation against the petitioner is that my lord, in the next page 10 of the FIR, my lord.
What is your name? Amir Shah?
No, my lord, my name is Sohail.
Sohail Khan.
Sohail Khan. Page 10, my lord, the last paragraph. My lord. Name of some Afghan national who obtain Indian documents illegally along with their phone numbers are given below for your information. This is the main allegation, my lord. Now you will also kindly say, admittedly, my lord, my father is a Pakistan national. I entered India in the year 1945. I have annexed it, my lord, that it has page, my lord, 27. My first entry.
No,
And there,
in page 10, where is your name? Number 4.
yes, my lord. Number
So,
4. Now you will also kindly see page 27. This is the identity card issued by the government of Assam. Joint Secretary of the Government of Assam Passport Department. And here, my lord, my date and place of arrival in India in column 8, my lord, 1945,
Page number?
27.
Yes.
Yes. Lordship, see serial number 8, my lord.
27 is Gul Khan.
Gul Khan. My father name is Gul Khan.
Okay.
He arrived India in the year 1945. This ID card was issued by the Joint Secretary to the Government of Assam Passport Department. And the next page, Miller. This is residential permit. Time to time, it was extended, my lord, and the last extended up to 31st 12th 1993. Thereafter, my lord, my father called ill, my lord, and he died on 29/9/1994. Page 30, page annexure 9.
Yes.
Now, my lord, your lordship, kindly see, I have born prior to 1st of July 1987. So I'm automatically became the citizen of India as per the Citizenship Act. My lord, now my your lordship, kindly see my birth certificate. Annexure 2, page 90. I born on 15/8/1981. Page 19.
Page?
19.
Yes.
This is my birth certificate, my lord. Date of birth is 15/8/1981. The next page is my school certificate, my lord, matriculation certificate.
Yes.
The next one is high school living certificate, my lord, first living certificate, page 20, annexure 3. Thereafter, my lord, voter ID card. After that, my lord, Aadhaar card.
Okay.
Thereafter, driving license, bank passbook, and my lord, money lender, under the Money Lender Act, my lord, a certificate was given. That is, I have annex at page 26, annex 6. So all the valid documents I have, it is extended up to 2026. After receiving the complaint, my lord, police has registered a case and constantly calling me to appear before the IR.
Okay, here the allegation is regarding fake passport and other documents obtained by them, lordship. He is named in the FIR. So let the city come, lordship, it's from Lokasil only. From Lokasil, lordship, allegations are very serious. And lordship, he has referred to one certificate at page 20 as been matriculation certificate, but it shows, lordship, that he studied up to class 3.
No.
Which
It is
certificate?
written there,
Matriculation.
page
Board of
20.
Hmm.
Rosebud English High School, class 3. I don't know what he's referring to. Also let the CD come, Lordship, because
My lord, I have all the documents, my lord. Even, my lord, your
Lordship,
lordship,
exactly, that is the allegation, that these documents are forged. So let-
No,
let
no,
us-
but
an allegation
accusation
was
is
against
not
three
a,
person.
mere allegation is not enough.
Not enough, yes. So we must have that chance to show before Lordship, because the names are given, Lordship, against whom these findings are given in page 10. He specifically named, Lordship, that page passport has been issued. So at least
No,
that part, Lordship, will kindly see.
that is an allegation only by,
Yes. No, it was done
that
after
has to
some.
be verified during investigation.
Yes. Yes, Lordship, but Lordship, allegation is not against X and Y, Lordship. They have been named, Lordship. Some materials have been found, therefore, Lordship, primary Lordship. That is-
Suppose,
Lordship,
suppose
yes,
somebody names you in the affair
yes,
that you are
yes,
holding fake documents of identity.
correct, Lordship.
Is that enough to refute?
No, absolutely no. But in the FIR, Lordship, will kindly see
My lord, the
page 9.
FIR was mainly
No,
against
no,
three
don't
person.
interrupt, please.
Page 9, Lordship will see, they have named all these person. Here, Lordship will see their fake Indian passport were seized, their.
No, that is an accusation only. Now, when he is able to produce documents,
Lordship,
now whether these are valid documents or not,
yes.
this is to be investigated. So
I do-
let him produce those documents before the
I
IR.
go down to your Lordship, then Lordship will give us an opportunity to place the case diary before your Lordship on Monday. Lordship will kindly go to the case diary and grant him appropriate relief, Lordship, from Latasil, Lordship. Monday, Lordship will produce it. Lordship, only because the allegations are serious, I am praying before your Lordship to give an opportunity to us. From Latasil, Lordship, nothing will happen, Lordship.
And that
Only because of the allegation I'm stating, Lordship. Because otherwise, Lordship, some people have approached, Lordship, in other cases also, Lordship, where they were not named in the FIR, Lordship. That is separate case, Lordship. But here he is named. Details are given, Lordship. That is why, Lordship, I'm submitting. Let the CD come Monday, Lordship.
if I don't produce the document, my lord, the police cannot investigate the matter.
Monday, Lordship. I'm
For
just praying for Monday,
investigation,
Lordship.
I need to be present before the
What
IO.
else can I do?
Only then they can investigate, my lord. Otherwise, how can they investigate?
Heard, Mr. What is your name? I, Rafiq, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS 2023 has been filed by the petitioner Mohammed Suhail, who is apprehending his arrest in connection with Lotasil PS case number 75 slash 2025 under section 3 within bracket 3 of passport within bracket entry into India Act 2020, read with section 14 within bracket C and 13 within bracket 1 of the Foreigners Act, read with section 336 within bracket 3, 346 within bracket 2, 61 within bracket 2, A, 2 within bracket A of BNS and section 12A of Assam Money Lenders Act 2022. The gist of accusation in this case is that on 31/7/2025, one Prasanta Barua, Chief Editor, Daily Agradut, had lodged an FIR before the Deputy Commissioner of Police, Guwahati Central, inter alia, alleging that some Afghan nationals have come to Guwahati and involved in the business of money lending without any valid documents. It is also alleged that the Afghan nationals named in the FIR, including the present petitioner, have obtained have illegally obtained the passport / Aadhaar card / voter ID card / PAN card in their name with the help of some scrupulous broker gang in Guwahati. Learned counsel for the petitioner has submitted that the petitioner was born at Guwahati on 15/8/1981, and in support of the said's submission, he has produced his birth certificate, which is annexed as Annexure 2. Learned counsel for the petitioner has also submitted that the father of the petitioner, namely Gul Khan, was a Pashtun,
Yes, ma'am. Pathan.
and he came to India in the year 1945, and to that effect, and to fortify his submission, he has produced the identity card of the father of the petitioner, which is annexed along with the bail application. Learned counsel for the petitioner has submitted that the petitioner has validly obtained all the documents of his identity, including the Aadhaar card and PAN card. It is also submitted that the petitioner has also been granted registration certificate under Rule 10 of the Assam Moneylenders Act 1934 to do the business of money lending. The said certificate is annexed along with the bail application as Annexure 6. Learned counsel for the petitioner has submitted that the petitioner is ready to cooperate in the investigation and is ready to produce all the documents before the investigating officer so that the veracity of said documents may be examined by the investigating officer. He submits that he is ready to cooperate in the investigation and hence prays for allowing the grant of bail to allowing him to go on anticipatory bail stop. On the other hand, learned additional public prosecutor has opposed the grant of any interim protection at this stage and has prayed for calling of the case diary, considering the fact that name of the petitioner has been specifically mentioned in the FIR lodged in this case, and the accusations leveled in the FIR are serious in nature. I have considered the submissions made by learned counsel for both sides and have gone through the records, materials, gone through the documents annexed along with the bail application. Let the case diary be called for. Let this case be listed again on 19th of August, 19th of September. However, in the meanwhile, considering the submissions made by learned counsel for the petitioner, as well as the documents annexed along with the bail application, the petitioner is directed to appear before the investigating officer of Latasil PS case number 75/2025 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with the aforesaid case, he shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Number 1 and number 2, list accordingly.
Briefly, well, this item is also in reference to the same police case similar. Here also, the petitioner has all the documents needed, including passport, and admitted his father has come from Afghanistan.
He also has documents.
Including voter list, I card.
Same FIR.
Same FIR.
When did your father came?
My father came in the year 1942. I have annex annexed 2A. The type copy.
What is the name of your father?
My father's name is Gulab Khan.
No schooling documents, Lordship.
That is studied.
No schooling certificate. He didn't study. He did not have an education. His birth certificate was issued on the 1/2/2025, this year. At page 20, Lordship will kindly see. Date of issue of the birth certificate.
Yes.
Down below, Lordship will find his birth certificate was issued on the year 1/2/2025. He does not have any educational qualification. He did not attend any schooling.
Where
is the birth certificate?
Birth certificate
Page
is
20.
at page 20 annexed 2.
Page 20, down below, Lordship will find.
He is registered
Date
in
of
the year
issue.
2025.
Yes. No, validity can be ascertained by the IO immediately from the issuing authority, whether it is valid or invalid.
There can be a certain Lordship. I'm just pointing out the fact.
It was
Time
issued
of
in the
issue,
year
Lordship,
2006.
He did not have any educational qualification. He did not attend any school.
For that,
And
term,
even
how
then,
can-
even then, Lordship, the birth certificate, he has all other documents, Lordship, but he did not have the birth certificate, Lordship.
Well, I myself
He
have
has
done a
residential
birth
certificate, he has every document, but he did not have the birth certificate, which has to be issued in this year only, Lordship.
Not this year, it was issued in the year 19/2006, date of registration.
Which according to you raises doubt.
Yes, Lordship. It raises a doubt, Lordship.
Well, it was registered in the year 2006, not 2025.
Okay. Heard Mr. I. Rafiq, learned counsel for the petitioner. Also Mr. B. Sharma, learned additional public prosecutor. This application under section 482 of BNSS. The FIR is same FIR.
Same FIR.
First para, same. Acquisition, same. Learned counsel for the petitioner has submitted that the petitioner was born at Samaguri in Nagaon district.
Nagaon district.
In Nagaon district on 15/2/1986. And his father namely, what is the name of
Gulab
Shah Oli Khan, alias Gulab Khan, came to India in the year 1942. What is the name of your father?
Gulab Khan.
And Ilyas?
It was written earlier, but in
But you must know the name of your father.
Gulab Khan, he is known as Gulab Khan only. In the
But
portal
in-
is also Gulab Khan.
Come to page 22.
Yes, it was written as Shah Ali Khan alias Gulab Khan. Now you should kindly see the voter list issued page 24 annexure 3.
Know whether Shah Ali Khan is your father or not.
Yes, ma'am, same person alias. One and same person.
Shah Ali Khan, who came to India at Amritsar in the year 1942. He also submits that. Do you also have money lender certificate?
Yes, ma'am, I have.
That the petitioner is in the business of
Annexure 5 page 31.
money lending, and to that effect, registration certificate. What is your name?
Rian Khan.
Registration certificate to that effect has been issued by the assistant registrar, issued by the government of Assam, issued by the office of the assistant registrar, Cooperative Society, Government of Assam. A copy of the same has been annexed along with the bail application. The petitioner has also annexed his passport issued to him on 15/11/2019, and validity of which extend in 14/11/2029. Learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation and produce all the documents of his identity before the investigating officer for verification, and therefore seeks protection from this court. On the other hand, learned additional public prosecutor has opposed grant of any interim protection at this stage and has prayed for calling of the case diary. He has also submitted that considering the nature of accusation, the no interim protection should be granted to the petitioner at this stage. He has pointed out that though the petitioner was born on 1986, however, no document regarding, have you gone to school?
No, ma'am.
No document regarding his schooling is there on record, which raises suspicion regarding the veracity of the documents submitted along with the bail application. Let the case diary be called for fixing same day, 19/8/2025 for case diary. However, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, as well as the documents which are annexed along with the bail application, the petitioner is directed to appear before the investigating officer within 7 days from the date of this order, along with all his documents of identity in original, and cooperate in the investigation. if he does so within the stipulated period of time, comma, in the event of his arrest in connection with above noted case, he shall be granted interim bail of rupees 30,000 with one security of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. List accordingly.
Next item is also the same matter. Here his father entered India in the year 1947. And on 11/9/2062, he was allowed to stay till disposal of his application for citizenship. I have annexed it as annexed 8 million.
Thereafter, what happened?
Thereafter he died, and prior to 1 July 1987, I born. So I am a citizen of India by birth. I have all the documents.
See, so and so. First paragraph, same Takibo. Name of the petitioner, Amir Ahmed. Shah, list of acquisition, same. Learned counsel for the petitioner has submitted that the petitioner was born on, where is your birth certificate?
Birth certificate, annexed 2, page 20.
Was born on
5/6/1996.
1996. 1996.
96. Date of birth, 96, maybe date of birth. Yes, 96. Sorry, madam. Yes, madam, 96.
1996. And his father, namely Ahmad Shah, came to India in the year 1947.
His grandfather came to India in the year 1947, madam. Grandfather.
Where is that document?
Annexure 8, page 30.
His grandfather, namely, what is the name?
Darya Khan.
His grandfather, namely Darya Khan, came to India in the year 1947. And thereafter, where is the permission that you can?
The same annexure, madam. May I read, madam? Sri Darya Khan, son of Jafar Khan, is allowed to stay at Burma Bazar, Shamuguri Police Station, Nagaon District, Assam, till the disposal of his application since submitted to the Government of Assam for granting him citizenship certificate. He should not move from place to place without obtaining prior permission from this office.
Page number?
30, the last, page number 30.
Thereafter, his.
And he entered, and his identity card is the next annexure 9, page 32. And his son is Ahmed Shah, who is my father. His passport I have annexed. Annexure 7, page 29.
Is the Lalika. And was allowed to stay in at Baram Bajar in under Samaguri police station till his application for citizenship is settled. The counsel for the petitioner submits that the petitioner is this. The name of the father of the petitioner is, what is the name?
Ahmad Shah.
Ahmad Shah. He also submits that. Where is your certificate, that-
Others, my lord.
no. That money lending,
Money.
it is not there.
I am not any of this money lending. Money lending is not available. My lord. His passport, his father's passport is available.
Your passport is there,
Yes, my lord.
where?
My passport is at S24 NHF5.
It is also submitted by learned counsel for the petition. Now that petitioner also holds passport of India. Which was issued to him on 5/3/2018 and which is valid till 4/3/2028. It is submitted by learned counsel for the petitioner that the petitioner is ready to cooperate in the investigation and ready to produce all the documents before the investigating officer for its verifications. On the other hand, learned additional public prosecutor has opposed the grant of any interim protection to the petitioner at this stage, considering the nature of acquisition in the FIR. Let the case diary be called for. Let this case be listed on 19th of August 2025. However, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraph, as well as considering the documents annexed along with the bail application, the petitioner is directed to appear before the investigating officer of Baki same as it is 30,000 with 170. List accordingly on 19.
Deeply obliged.
What is item 54?
It's an IA, interlocutory application. The situation arises in this fashion that
Then whether judgment can be pronounced now?
because there's a fraud upon the court. So that just pronouncement of the judgment has to be postponed until we are heard.
This application is under order 41 rule 27. Yes. What do you say?
In a second appellate stage. In fact, your lordship, if the appeal is not admitted under section 100, if this court finds that there is no substantial question of law, there cannot be any occasion for for a petition under order 41 rule 27.
You
It's read with
Order 41 rule 27 will arise only after admission
so
of
we have to dispose of this interlocutory application,
application.
giving reasons. Then
Yeah.
only,
That can be considered only if the second
yes,
is admitted.
yes, that may be one ground. But
Okay.
but we have to decide this interlocutory application first before pronouncing the order, whether the appeal would be admitted or it would be dismissed.
there is also a settled position of law that upon discovery of a fraud, any court, anywhere can take cognizance. So that is the settled
At
position. of law.
any stage.
Yes.
You response to this interlocutory application,
Yes.
how much time will you require?
Next week, your lordship. 1 week time maybe.
Heard, miss, what is your name?
A site,
A
Psychia, SAIK.
Saikia, learned counsel for the applicant. Also heard Mr.
BJ Mukherjee.
B.J. Mukherjee, learned counsel for the respondent. This interlocutory application has been filed by the applicant slash appellant in connection with RSA number 236 slash 2024 under order 41 rule 27 of the CPC 1908, read with section 38 of Bharatiya Sakshya Adhiniyam as well as section 17 of Limitation Act. Learned counsel for the applicant slash appellant has submitted that the respondent as plaintiffs in the trial court has obtained the decree in their favor through fraudulent means, and therefore prays for production of additional evidence at the appellate stage. Learned, on the other hand, learned counsel for the respondents submits that this application under order 41 rule 27 is not maintainable in as much as the connected regular second appeal is yet to be admitted. He, however, seeks a week's time to file his response against the interlocutory application. The prayer is allowed. Let this after a week on a date, let this interlocutory application be listed after a week on a date to be fixed by registry. In RSA 236, heard Swen's presence the capo. This RSA was, this regular second appeal was fixed for delivery of orders. However, in view of the filing of interlocutory application number 1949/2025 by the appellants, the delivery of order is deferred and it would be subject to the outcome of the interlocutory application filed by the applicant. List accordingly along with the interlocutory application after a week.
Lordship has heard it considerably if it is kept intact with this bench, your Lordship, as part heard at least.
No, that will remain part heard because
It is heard at
It's
length.
kept for judgment, so therefore it will be heard here.
yes, let this matter be,
What about fixing a date? Lordship may fix it.
yes, you suggest a date. Mr. Mukherjee, you will have to respond.
Because, you know, you will be filing. so
Yes.
we are going to let you-
In second week of September, your Lordship.
Let the case come 31.
11.
11. Let this case be listed on 11th of September.
Much.
Because we will step in.
Personally, I didn't want to withdraw.
I may be allowed to withdraw the petition.
What is your name?
Ms. J. Akhtar.
Heard Ms. J. Akhtar, learned counsel for the applicant. Learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. The learned counsel for the petitioner submits that the petitioner may be allowed to withdraw this instant bail application. The prayer is allowed. This bail application is dismissed on withdrawal.
My lord, maybe taken a little bit, later, my lord, senior governor, but he is coming, my lord, he is in lakes in other court, my lord, just after 10 minutes, my lord, he is just coming, my lord. One matter, yes, my lord.
Let him come. Be Mr. Nath.
Not, 10 minutes, he will be good.
It is there.
He is there, my lord, he is.
Case there is there on.
Yes, yes, case there is available.
Let him come. We'll take it up after some.
Yes, Your Lordship, this matter relates to the territorial jurisdiction knowledge, where the petitioner had taken a loan, vehicle loan from a finance company, that is the respondent company.
No.
According with that matter, my
I
lord.
remember this matter.
Yes, my lord. Yes,
Here, you have to satisfy me.
my lord. I have,
Let me put query.
the other day I made, submitted some decisions, my lord. These are there, my lord. One is, my lord, case number 4330/2017, Ashok Kumar Pansari works at the state of Meghalaya and others. And
Which one?
I have placed, my lord, these are in records. And another, my lord.
No, which one? First one is?
First one is the Ashok Kumar Pansari, my lord.
Okay, what it says?
Relevant paragraphs, my lord, from 9 to 13, my lord. Here, my lord, the occurrence took place in Khanapara, my lord, and the FR was lodged in Meghalaya, and the writ petition was filed in the honorable, before this honorable Guwahati High Court at Guwahati, my lord.
Okay. Next one.
Next one, my lord.
Who is appearing for the state?
My lord, I am with you.
Ms. Chaudhary. I have a query. In this case, the cause of action for approaching this court is passing of order by Kolkata court. That is the cause of action, not the transaction between the parties. You are invoking this court's writ jurisdiction to prevent Kolkata courts from taking cognizance.
Worship may kindly say I have filed one additional affidavit, where I have enclosed, my lord, the complaint petition. Your lordship may kindly see my additional affidavit, my lord. Here I have annexed one complaint, the complaint petition that is was filed on 18/12/2024. Then after filing of the complaint petition, my lord, the respondents finance company, they have initiated the arbitration proceeding, my lord. And they have also issued notice dated 19/4/2025 and 6/5/2025, annexure 2 and 3, my lord. After filing the complaint petition, my lord. So they have initiated two proceedings at the same time, my lord. And as per the terms and condition of the agreement also, it was there that if any dispute arises in respect of the loan, my lord, it should be settled by the arbitration. At page, arbitration notice at page 18 and 38, 38 and 41, my lord.
Yes.
And my lord, one similarly situated case here, only the difference is the finance company is different. The petitioner belongs to Karimganj. All the transaction took place at Karimganj, but the petition was filed at Calcutta. This honorable court has, my lord, entertained this petition. But in that petition also, the maintainability of question of maintainability was raised, my lord. But subsequently, it was entertained, and my lord, interim order was also passed, my lord. Notice was issued. This is the order, my lord.
Whether the question of maintainability was decided.
Yes, my lord, in this case. This is pending. now.
35, 35
Uh,
of 24,
8 weeks.
35, 24.
30.
Yes, yes, ma'am, yes, yes. In that case, my lord, the last order is of 19 of August, my lord. With State of West Bengal also is a party. Now they have paid for deleting from the area of the respondent. Accordingly, State of West Bengal has been deleted. In that particular case, WP criminal 35 or
But
24.
interim order is there. Notice was issued.
Yes, Mr. Parashar. What is your submission?
My lord, yes, the insurance company may have done wrong, my lord. They have to file proceeding within the territory of Assam or maybe through the other proceeding, my lord. But now challenge in this petition is that regarding the notice and subsequent orders, summons has been issued. Now, if Malar has to call for the records, whether registry of this court can call, cannot. And we cannot bring those records from the court. How can we decide in Malar? They may done wrong, Malar, but appropriate remedy can be sought before the court at Kolkata, Malar, Kolkata High Court, Malar.
Okay, I'll pass orders later on. Heard Miss
SB Chaudhary.
SB Chaudhary, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. Both the council have addressed this court on the question of maintainability. Let this case be listed for delivery of orders on on 5th of September.
Item 37.
37, my lord, maybe taken after some time, my lord. Kuldeep Buster has gone through, he is in other court, my lord, he will come, my lord.
Yeah, after some time.
No.
Today we don't have much time.
38.
May I please, your lordship?
Yes,
Your lordship, may kindly grant us a short period of time to file our objection in this matter.
In this case, all the other courts have been enlarged on bail. The main accused has been also enlarged on bail by this honorable court 5 order dated 27 to 25 lordship. So lordship, already the trial has commenced. Out of the 13 numbers of prosecution witness, 3 has been
how much is the contraband?
contraband was 119 kg lordship.
Of?
Ganja, your lordship.
Ganja lordship. It was recovered from the Sagan Mia, the main accused, and he was granted bail lordship.
How much time will you require?
Chip, fix it on 3rd of September.
No, lordship, already he has behind the bar for 2 years, 5 months, 11 days, lordship. He's behind the bar.
Yes, seeking 3 more days. Let them, if they fail to file objection, we will proceed.
Shorter date may be given, lordship.
Heard Miss R. Hussain, learned counsel for NCB, who prays for some time for filing written objection against the prayer for bail made by the petitioner. Also heard Mr. KK Hendik, learned counsel for the petitioner, who opposed the prayer on the ground that the petitioner has been languishing behind the bars for more than 2 years.
5 months, 11.
5 months, and all other co-accused have already been released on bail. However, considering the submissions made by learned counsel for NCB, one chance is granted to NCB for filing written objection. Let this matter be listed on the 3rd of September.
Lordship.
39.
Petitioner behind the bar today 60 days lordship and
Well, otherwise materials are there, today is 59 days, I have calculated, well, otherwise on length of detention only, my lord.
Heard Mr. A.B.T. Hawk, learned counsel for the petitioner.
All sections are up to 7 months.
Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application on this and 483 of BNSS has been filed by the petitioner, namely Abdul Matleb, who has been detained behind the bars since 1/7/2025 within bracket for last 59 days in connection with Bishwanath Charali PS case number 105/2025 under section 61 within bracket 2/318 within bracket 4/316 within bracket 2/318 within bracket 2 of BNS, read with section 43/66/66C/66D of the IT Act. Learned counsel for the petitioner has submitted that for all the offences involved in this case, the maximum punishment prescribed in the statute is not more than 7 years. And therefore, maximum period of detention under section 487 of BNSS is 60 days only. Maximum period of detention during investigation under section 4 is 60 days only. He submits that the petitioner has already been detained, already completed 59 days behind the bars, and considering the period of detention, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Bishwanath Sarali PS case number 105/2025 and has submitted that there are sufficient incriminating materials in the case diary against the petitioner. However, he also submits that the investigation has fairly progressed. I have considered the submissions made by learned counsel for both sides and have gone through the case diary produced by learned additional public prosecutor. Since the petitioner has completed 59 days behind the bars and the investigation has fairly progressed, hence considering the period of detention as well as progress made in the investigation, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Bishwanath, with following conditions. Number 1 and number 2. Then back the case diary. This bail application is accordingly disposed of.
41.
Yeah, I would pay.
May I please?
Yes.
This is basically, my lord, what happened in this case, my lord. The these are the two petitioners. The company, they have outsourced us, my lord, for supply of, my lord, diesel for the company provides it for running up various machinery. For that purpose, my lord, what they did, my lord, they have given us a petrol card, man. It's basically a sweeping card.
Petrol card.
Yes, petrol card, it's like a ATM card.
Yes.
So they have to infuse the amount in that card, and on the basis of that card, we can purchase the petrol from the various pump station. We cannot purchase from the cash. whatever the requirement, we'll collect it, we'll purchase it from the bank, from the petrol pump by using that particular card, man. So that the amount we purchase, that will automatically will be reflected in the statement itself, my lord. In the bank statement, whatever the amount, because it's connected, my lord. So there's no question of any evading, my lord, or doing any mischief. Whatever we can purchase, that will automatically get reflected in the bank statement.
Monetary role or control.
So there is no monetary role at all here involved on our part. Simply our duty is to purchase by using that particular card. That's an admitted proposition as and the FR itself.
Collect and deliver.
We collected and deliver it in their premises, my lord. Then they collect it and accordingly we get the whatever the percentage from the company itself. That is the modus of the supply, man. Now during that process, my lord, last 5 months, one employee of the company, Mr. Murthy, he has done some manipulation and thereafter he has been charged. And during that, the company has found that we have paid some amount to Mr. Murthy. So under that premises, my lord, under the apprehension and the suspected that why we have paid some amount to the Murthy, they have also implicated that we might also involve in this case. So that is the basic case, basic facts of the case, my lord. So everything is the, my lord, the whatever, it is the on record, my lord. Whatever we have supplied, whatever between purchase and the purchase and supply, my lord, that cannot be manipulated. Whatever they have required, we have to use that particular petrol card and that will be reflected in their accounts. We cannot purchase less or more, whatever we purchase.
You purchase from where?
Any
petrol
pump we
pump.
can purchase.
Okay.
But we have to only use that particular card.
IOCL and BPCL petrol pumps because there were two cards.
So basically IOCL petrol pump, but whatever may, well, that we have to use it so that it automatically get reflected in their accounts, that the amount we have purchased and the price, both will be reflected that we have purchased today 5 liters. Then the 5 liter purchase, that definitely while the shipping the card, it will get reflected in their accounts, bank accounts.
Whose bank account?
The companies.
Okay.
The companies, they have provided that petrol card.
Informant companies.
The informant. It is not our card.
Okay.
It is provided by the informant in the FIR, it has been reflected. So we cannot manipulate anything regarding the purchase.
What is the acquisition level?
Acquisition is that this Mr. Murthy, their own employee, he has manipulated after receiving that particular diesel and probably he has misappropriated that sum. And then there is a belief that we have paid some amount to Murthy, my lord, that we are also involved in the conspiracy. That is their charge, my lord. On the basis of that amount, my lord.
Okay.
They have found that the Murthy has invested some amount in somewhere because his basic salary is 40,000, but his pay,
Yes.
his account, the more amount has been shown. He is doing some other trading, etc., etc. So now the most moot question is that, my lord, the whatever charge, my lord, as I have already said before your lordship, I'm just reiterating that this is all the 7 years punishment, my lord, whatever the charge may be. So the requirement is that as per the Until and the Ernest Kumar, the basic requirement is that first you have to serve the notice to the person concerned, and if you can also arrest without the notice, there is no bar at all. But for that you have to give the reasons in writing. That is the requirement of the law. My lord,
reasons not for serving the notice.
And the serving the notice is more important. Why you have not served the notice? No. Here they have given only the grounds.
Reasons for released.
The grounds they have cited, my lord. Grounds, because lordship knows as per there are 5 grounds, there is always there. But the mandate is that you have to come to a conclusion, police officer, that yes, these are the grounds. But whether the arrest is required for committing these offenses, my lord, under these grounds. That is the requirement of the law in the statute also, it is very clear in the 35 itself that the police officer shall record while making such arrest his reasons in writing. That is the 35, the last line after E, my lord. 35, any police officer may, without an order of magistrate and without a warrant, arrest any person. Now, against whom the reasonable complaint has been made, credible information has been received, a reasonable suspicion exists, etc., etc. Then, two, police officers satisfied that such as arrest is necessary to prevent the person from committing any further offense, or to proper investigation of the case, or to prevent such person from causing evidence of the appearance disappear, tampering and the evidence in manner, or to prevent such person from making any inducement, threat, or promises to any person acquiring with the facts of the case, so that to deceive any from disclosing the facts of the case. And as unless such person is arrested, his presence in the court whenever required, it cannot be ensured. This is the ground they have cited in the, my lord, forwarding. Only this is the ground. Now next, and the police officer shall record while making such arrest his reasons in writing. So these are the grounds, but reasons is different. His own reasons why this is necessary, because he has to come with a conclusion that the arrest is necessary for these are the, and it has to be based on facts, my lord. Not his own choice of grounds, my lord. It has to be based on some facts. Now, what you kindly see, and what you kindly take up the Satyendra Kumar Antil's paragraph, my lord. 25 onwards, 24 onwards, my lord. Yes, 24, my lord. These provisions at 41, my lord, these provision mandates the police officer to record his reasons in the writing while making the arrest, my lord. Always the reasons, my lord. It's not the grounds. Thus, a police officer is duty bound to record his reasons, again, my lord, for arresting in writing. Similarly, the police official shall record reasons when he or she chooses not to arrest. There is no requirement of the aforesaid procedure when the offense alleged is more than 7 years, among other reasons. The 25, the consequence of non-compliance of 41 shall certainly inure the benefit of the person suspected in the offense. Resultantly, while the considering the application of enlargement or bail, court will to satisfy themselves on the due compliance of this provision, any non-compliance would entitle the accused to grant of bail. 26, my lord. 41A deals with the procedure for appearance before the police officer who is required to issue a notice to the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense and the arrest is not required under section 41A or 41B deals with the procedure of arrest along with the mandatory duty on the part of the officer. Next, my lord. On the scope and objective of 41 and 41A, it is obvious that there are facts and facets of Article 21 of the Constitution. We need not elaborate the further in light of the judgment of so and so, so and so. Now, from the plain reading of the aforesaid provision, it is evident
that a person accused of an offence punishable with imprisonment term which may be less than 7 years or which may extend to 7 years with or without fine cannot be arrested by police officer only on his satisfaction, my lord. That is very only on his satisfaction. And such person satisfaction that such person has committed the offence punishable as aforesaid. A police officer before arrest in such cases has to further satisfy that such is necessary to prevent such person from committing any further offence, 1, or the proper investigation of the case, that is 2, to prevent the accused from the causing the evidence of the offence to disappear, 3, the tampering with the such evidence in the any manner, 4, to prevent such person from making any inducement, 5, threat or promise to the witnesses as to dissuade him from the disclosing such facts to the court or to the police officer, 6, or unless such person is arrested, his presence in the court whenever is required cannot be ensured. This is the 6. These are the conclusions which may be reached based on facts, my lord. So it has to be always based on facts. Simply just reproducing the language of the statute will not do. He has to give an addition to that. He has to give his own facts on the basis of which he has come to the conclusion that yes, there is a possibility. Suppose that he said that this person cannot be ensured after he is granted bail. But that fact has to be that in a previous case, sometimes he has jumped the bail.
Why he is arriving at such a conclusion? That reason has to be there.
Yes.
Why
yes,
he is arriving at
yes,
such a conclusion?
Yes, that is the necessity, my lord. While not based on
Facts must be there.
Yes, facts must be there. Only simply just reproducing the
The
statute,
statute language,
that cannot be.
what he has done in this case.
It's nothing, my lord, simply one line there, page 25, that the notices is not served only because if he is allowed to go on bail, he may not be. Page 25, my lord. The last paragraph from the bottom, my lord. Further, as your lordship got it. my lord. Further, the notice under 35(3) is not comply. That means is admitted that notice has not been served to the accused person, as the accused person are found involved in the fraud case of the huge quantity of the money, and if the accused person released and comply with the notices 35(3) BNSS, they will hamper the investigation and tamper the evidence, madam. It is his understanding that if they are released, they may hamper and tamper the investigation. But from where they have come to the conclusion that they will hamper and tamper, my lord. That reasons is absence, my lord. That is my case, my lord. And the second part is that, again, my lord, I'm taking some time in this case, my lord. Sorry, my lord. The lordship kindly see the 7.2 of the paragraph 27, again, my lord. The law mandates that police officer to state the facts and the records of reasons in writing, which led him to come to the conclusion covered by any of the provisions of the aforesaid, my lord. Yes. So again, my lord, he has to again reiterate 7.1 in 7.2 while making such errand. The law further requires the police officer to record reasons in writing, not for making the arrest. So if he doesn't make the arrest, even then also he has to read the reasons. In pitch and core, the police officer before the arrest must put a question to himself, why the arrest? Is it really required? What purpose it will serve? What object it will achieve? If it is not after this question are addressed and one of these other condition is enumerated above, the power of the arrest needs to be exercised. In fine, before arrest first, the police officer should have reasons to believe on the basis of information and the material that has accused has committed the offense. Apart from that, police officer has to be satisfied further that arrest is necessary for one of the more purposes envisaged subclause 1 to A and section 41 CRPC. Now, the next part. 8.2, my lord. Now this is the part of the magistrate. Before a magistrate authorize the detention of 167 CRPC, he has to be first satisfied that the arrest is made is legal in accordance with law and all constitutional right of the person arrested is satisfied. If the arrest is effected by the police officer does not satisfy the requirement 41 of the code, magistrate is duty bound to not to authorize the further detention and release the accused. In other words, when an accused is produced before the magistrate, police officer effecting the arrest is required to furnish to the magistrate the facts. What are the requirements, my lord? The facts, comma, the reasons and its conclusion. Only that, my lord, the reproduction will not do for arrest, and the magistrate in turn is to satisfy that the condition precedent for the arrest 41 CRPC has not been satisfied, has been satisfied. So it is the why this notice was not served. That is, the notice is required under 41. So if the notice was not given to the accused, then now it is the duty of the magistrate to see that yes, there are specific reasons based on facts which demands that yes, notice is not required in this case, my lord. That satisfaction magistrate has to arrive from these papers and forwarding and the checklist. There are two things, my lord, forwarding and the checklist. It may not be in the forwarding, the reasons, but it may be in the checklist, reasons. Checklist also, that same reasons has to be given, my lord, why the arrest, not only in the forwarding. I'll come to that, my lord. So then the magistrate, on perusal of the both, he has to give his own satisfaction in writing, may not be in brief. My lord, next paragraph, my lord. The magistrate, before authorizing the detention, will record his own satisfaction, maybe in brief, but the said satisfaction must reflect from his order. That's very important, my lord, that his satisfaction. It shall be never be based upon the ipsa dixit of the police officer. That's very important. He may give thousands of reasons, my lord, grounds for such person non-committing any further offences for the purpose of investigation of the case or for preventing the accused from the tampering of the evidence, for making the inducement, etc. The police officer shall furnish to the magistrate the fact, the reasons and the material on the basis of which the police officer has reached its conclusion, my lord. That's very important, my lord, the most important. The police officer has reached its conclusion on the basis of the hard facts. That has to be satisfied to the magistrate. And after recording his satisfaction in writing, that the magistrate will authorize the detention of this accused. In fine, when the suspect is arrested and produced before the magistrate on authorizing the detention, magistrate has to address the question whether the specific reason has been recorded for the arrest, and if so, prima facie, those reasons are relevant, most important. Secondly, a reasonable conclusion could be at all be reached by the police. Reasonable conclusion. What is it? Here, the ground is that we must tamper with the evidence, my lord. From where he has found that reasons, my lord? That has to be based on some evidence. Reasonable conclusion could be reached by the police officer that one of the other condition has stated above are attract. To this limited extent, the magistrate will make judicial scrutiny, my lord. So basically, my lord, the magistrate is sitting on an appeal on the basis of these. So he will scrutinize, my lord, whether these reasons or the facts is relevant, connected, and necessary. Simply will not do, my lord. The 9, the aforesaid provision makes it clear that in all cases where the arrest of a person not required under section 41 CRPC, police officer is required to issue notice directing the accused to appear before him at a specified place and time. Law obliges that an accused person appear before the police officer and further mandates that such accused complies with the terms of the notice. He shall not be arrested unless the reasons to be recorded. So after notice also, he can arrest the person, my lord. Here, it's not even done. It's not that after notice they cannot be arrested. he said that if we issue the notice, you will be released on bail, we cannot arrest him further. But it says, after notice and say if there's a reasons you found during the interrogation that yes,
Yes.
my lord, the last line, I'm just reading the last line of the paragraph 10, my lord, last 3 lines. We would like to emphasize that the practice of mechanically reproducing the case diary, all and most of the reasons contained in section 41 for effecting arrest be discouraged and discontinued. So that means, my lord, simply reproducing.
Your submission is that is what has been done in this case.
Yes, my lord. Simply they have
He has
reproduced.
mechanically reproduced.
Yes,
the provi-
reproduce the statute which has been prescribed, but there's no reasons has been attached from where he has come to the conclusion, his own satisfaction that we may temper. He has to give at least one reason. Now, to bypass, not this is the minor checklist. Checklist for both the accused. There is a two checklists for both the identical, my lord. Now it is the Arihan Jain 29 years, my lord. Now lordship can see reasons for arrest. Whether the arrest is necessary to prevent accused from committing any further offense, simply yes. Whether accused is previously convicted, previously involved in the crime of the case, no. That means there is no reason. Whether the accused has previously jumped the bail, that's very important, my lord. Yes, no. That means there is no previous antecedent that he has jumped the bail. Whether accused has previously, whether he is a chance of jumping the proceeding of the accused is yes. Now there is no reason. Why? But his precedents say in the 3, it says otherwise. Whether accused is involved in permanent resident of Assam, yes. That's very important. Whether the accused of address is required to be verified, no. That means they are satisfied with the address. Whether is the further requirement of the accused of the discovery of the fact, yes. Whether the assistant, these are not the grounds in the statute, my lord. For discovery of facts is not, cannot be the, whether the assistance of the accused is required in affecting the recovery of the property, no. Then the now, lordship can come to 11, that's very important. Whether there is any chance of accused causing the evidence of the offense to disappear or tampering with the such evidence in any manner which may affect the investigation, simply yes, no reasons. In the 11. That is the ground they have incorporated in the forwarding. But here also in the checklist, there is no reasons at all. So this checklist also, my lord, is required in the, my lord, in the paragraph, my lord.
Your submission is that he has not stated the facts.
On which 11.3, my lord, in the judgment, it's also mandated, my lord, 11.3. Not only forwarding, my lord, also in 11.3, it's very clear, the police officer shall forward the checklist, filled and furnish the reasons and materials. In the checklist also, it's not that the only yes and no will do. They have to give the reasons and material which necessitate the arrest while forwarding the producing the accused before the for further detention. So in the checklist also, only yes and no will not do. They have to give reasons in the checklist. They cannot bypass. That's the mandate of the law, my lord.
Yes, Mr.
So in this case also, the magistrate order also filed. He has also, though, our specific ground in this case that this has not been complied with. In the page 34, the order of the magistrate, he simply says, no, now lordship can see what he has done. So-and-so been arrested, so-and-so both are in so-and-so before the court on so-and-so in connection with the so-and-so. Inspection memo, notice under 48 and 47, checklist for arrest without warrant, so-and-so, medical examination. So 47, 48 has been complied with.
IO so and so personally present heard the IO in the CR case upon perusal of material on record, finding the grounds of arrest to be satisfactory. I am of the view that the arrest person is justified, my lord. He has also has to give his own reasons that these are the reasons I am satisfied. There's no reasons at all. He simply said that the ground given by the is satisfactory. That's not the mandate. He has to give his own reasons why he is satisfied, the ground and given by the accused in this particular case. In the forwarding, there is nothing. Checklist, there is nothing. Where from he has come to this conclusion, my lord? That I am tampering with the term. He must say that yes, there is an allegation that I may tamper with the evidence, and there is a reasons for that, and I am satisfied with the reasons given by the police that there is a chance of tampering. Then only he is authorized to give my further custody. That has to be maybe brief, but he has to satisfy in his own. It cannot be ipso dixit of the police officer. Whatever they will reproduce from the statute, he will follow that. That is the necessity, my lord. In this case, my lord, my humble submission, it's not been followed. So we are absolutely, my lord, this detention itself is illegal as the arrest was illegal. Arrest itself is an illegal, my lord, because this has not been followed on the face of the record, my lord.
Okay, yes, Mr. Praj.
Yes, my lord. With all respect to Lanak Senior, my lord. First of all, manipulation cannot be done be in prepaid card, and in this case, manipulation up to the tune of rupees 1 crore has been done. Now, my lord, that Tata Semiconductor Assembly project has come, my lord, in Jagirod, my lord. This construction regarding is going on. That is 27,000 crore project. Now, regarding the construction, this killer company has been given to construct the piling and all this. During this process of construction, my lord, huge machinery has been involved. Around 80 machineries and all this, my lord. No. And nearby there are no fuel stations, fuel pump. Because of that, my lord, this petitioner's company, my lord, this is Fuel X. He has been, local company has been hired by the killer company to provide the, supply the fuel. Now for that, my lord, there are two prepaid card, my lord, given by the killer company, my lord. One is of IOCL, one is BPCL, to the tune of rupees 10 lakhs per day. They can purchase rupees 10 lakhs per day, diesel. Now, one Mr. Murthy, he is the, my lord, he was the employee of that killer company, that company. He used to register the stock, how much required for today. Every morning he has to tell these petitioners that I need this much of amount of diesel today, and accordingly they will supply. From anywhere, nearby petrol pump, from Guwahati also they were supplying. In that process, what they have done, if for today require 500 liters, for example, if for today require 500 liters, they took more than that. Say 700 liters they took. But actual quantity 500 liters has come. But they have swiped the card to the tune of regarding that 700 liters. Remaining amount, the petrol pump paid to this two petitioners. And subsequently, brother of this petitioner, petition number 1, petition number 2, he has paid rupees 3 lakh, more than 3 lakh to that Murthy. That person, his salary, Murthy is a Mr. Murthy is a employee of that company. His salary is only 40,000, and he has invested more than 50,000 in share markets and all this recently. Now, more than that, that petitioner number 2, he gave some screenshots. There are parts of the case there. Screenshots, GPay has been made directly by the petrol pump to that Murthy. Remaining amount, GPay has been made by the petrol pump to Murthy. But regarding that screenshots, given by the Sahil to Murti. Malat in a case dari, malat they have malat 40,000 received from this some pump given to Murti, but that screenshot has been given by petition number 2 to Murti. Now subsequently, when malat this is going on since December 2024, and around 20 lakhs rupees per month, the company getting lost. Now things come out how malad. One has reported that some less amount of diesel he get those days, and by checking the malad register prepared by that Murti, authority said that no, as per the document, you get the sufficient amount of fuel. But you say, no, I have not get the sufficient amount. But as per paperwork, which was done by Murti, sufficient amount given. Now, what they have inquired, malad, preliminary malad, before lodging this malad in the company, they have inquiry made malad around since till May, per month 20 lakhs rupees they have lost. Subsequently, that card was given to, prepaid card was given to this petitioner number 1. So you maintain. Now petitioner number 1 also, malad, in 1 month, 40 lakhs, 47 lakhs he has purchased. That is also more than that, malad. They don't require that such amount of petrol on that month, malad, in the month of June. And when malad FR file, malad, FR was lodged on 6th of August. And after the preliminary investigation, malad, arrest one only on 20th of August. Because now reason, malad, Lanet Senior has pointed out, malad, that part of the forwarding report, which is necessary with him, malad, but malad, Lanet Senior has pointed out page 25. That paragraph is further. So before that, malad, I am coming to page 24. Page 24, grounds of arrest to grounds of arrest 1 and 2. The part of the forwarding report, malad. Now, manipulation of record. Manipulation record by this Murti, malad. I am skipping, malad. Disappearance of evidence. This is also Mr. Murti, malad, and all of this. Now, suspicion financial transaction. The investigation uncovered that Mr. Murti had monetary transaction with which is Sahil Jain, brother of Aryan Jain. Sahil Jain is the brother, petition number 2. Owner of FuelX, through Google Pay, 3,20,000 rupees, as well as on cash, through FuelX staff. See Sahil Jain transaction rupees 1 lakh to the account of so and so Murti, February 25, so and so, malad. And in the case there are materials, malad, 1 person of that company, he was given cash. That person, his statement is that, malad, in some occasion, as asked by Sahil Jain, I have given money from, as asked by Aryan Jain. He given money to Murti. Regularly, not one occasion, malad. 4 or 5 occasions, he has given money. Aryan Jain has given money to Mr. Murti cash. And his brother Sahil, he is working here, doing business in here, Guwahati. He is Google Pay, not to the tune of rupees, to tell 3,20,000, but not once. 40,000, 50,000, on different dates, he has paid for Google Pay. And also screenshots from those petrol pump given to Mr. Murti.
Assuming that
there are materials.
there are materials.
Now grounds, reasons. In the meantime, that Murti, he suddenly one day, he fled away. Without assigning any reason, that person fled away. Because of this, now, main culprit who record has been made by that person.
I have a query. In the forwarding
report, yes.
Now listen to my query. In forwarding, you have mentioned the reason for dispensing with 35(3) notice as you apprehend that they may tamper with the evidence.
my lord.
On what basis you drew this conclusion that they may tamper with the evidence?
They are,
Requirement of law is that you have to mention facts, that
Yes.
because of these facts, I come to conclusion that they may
These facts,
tamper.
in page 25 itself, my lord, that paragraph starts as further abandon, my lord, para 3, page 25, para 3. Based on the above findings, it is evident that based on the above finding, evident that Mr. Murthy, in collusion with Mr. Aryan Jain and Mr. Sahil Jain of Coelex, was involved in a plan and systematic misappropriation of detail. So and so, these were given. This paragraph is further. Because of that, this notice, but already reasons has been given in 2 pages. And in the checklist also, whether any field, any column in the checklist is blank, my lord. In the every point has been given, yes or no has been given. Details in the forwarding report. But Learned Senior has pointed out only that paragraph which is start as further. So that means there are others previously given. Paragraph 3, if the below noted accused person is not arrested, there may be a chance of hamper and temper the investigation. Para number 5, my lord. Page 25, para 5.
Yes.
If the below noted accused persons is not arrested, there may be chance of hamper and temper the investigation. These are mentioned subsequently in this last paragraph further. And my lord, when they 3 persons, my lord, they all together to the tune of 1 crore, 1,000 of crore rupees has invested by that company, my lord, is coming to Assam, my lord. And now at the starting point, my lord, these persons are doing this. And my lord, one person, my lord, he fled away. Main culprit fled away till he is arrested, my lord. So these persons are required because of if, my lord, they call by providing notice. Then
No, their submission is very simple,
my lord,
that you can dispense with the notice, provided you give facts on which you drew the conclusion that the clause A,
Tampering with the
yes,
my lord, in my submission, page 24 and page 25, this paragraph 3, 4, the accused person forwarded to honorable court, they will help the accused Mr. Murthy, who is working as so and so. 5, if the below noted accused person not arrested, there may be chance of hamper and temper the investigation. This all has been given, my lord. And subsequently, further notice has been given. So in my respectful submission, my lord, sufficient reasons has been given. My lord, grounds of error is given, 47, 48 complied. And in the checklist also, no column is left up, not filling. Yes or no has been given. And detailed reasons has been given in the. And my lord, yes, another thing, my lord, I am pointing out, my lord, in the, he was arrested on, my lord, 20th of August. On that day, my lord, what GD entry has been made, my lord? There is GD entry, my lord, in the case diary. My lord may peruse this GD entry. At 12, subsequent to that, error has been made.
what is there?
That is, my lord, GD entry note. It is noted that during the in time of arrest of the accused persons, I have served them arrest memo so and so and so. These are given. Notice under 35(3), BNSS is not comply. The accused person, same line, my lord. The accused person is found to involve in the fraud case of huge amount of money, and if the accused person released to comply the notice so and so, 35(3), they will hamper in the investigation, tamper with the evidence.
So what I understand,
My lord.
that if the accusation is that huge amount of money is involved,
My lord.
then 35(3) can be dispensed with. That is the reasoning of the
My lord, co-accused fled away in the meantime. And paragraph five, they have mentioned, and further, because of this, that, my lord, I might have not supplied.
Okay, you give me the case diary.
My lord. And regarding repay and all these transactions, my lord, has been, I have flag mark.
I'm just one thing, my lord, just want to point out one thing. The reasons, my lord, they have given that we might tamper with the evidence. That is the reasons given, my lord. And for that, my lord, it was in the forwarding report, the allegation of the tampering, not against me, my lord. They're specific who has done the tampering. So if they cannot, Lordship kindly see the page 24, the disappearance of the evidence, that allegation absolutely against the Murthy. Page 24, when the question was asked to hand over the physical register, Mr. Murthy.
Where are you reading?
Paragraph 24, my lord.
Para?
Forwarding report, our my lord, petition, page 24.
Yes, page 24.
Manipulation and record. So manipulation of record, that means the tampering of evidence, that allegation is specifically against the Murthy, not against us. The Murthy was found responsible for maintaining daily fuel consumption record and the physical register following the preparation of the Excel sheet very morning, which was then shared with the relevant documents. The company observed that the fuel consumption data in the Excel sheet reflected higher usage than the affecting average consumption of the machine. On verification, it was found that the Murthy manipulated the Excel record, inflecting the consumption figure compared to those in the physical register. When the question was asked to hand over the physical register, Mr. Murthy abruptly left the worksite in April 25, citing a family emergency. In the April itself, we are continuing thereafter also. We are continuing supply. Murthy in 25. Subsequently, he informed the company that 2 physical registers were missing from the worksite, raising further suspicion. So, regarding the manipulation, it was always the reason maybe against the Murthy, but that has not been incorporated in our forwarding. So, there is no reason at all. And my learned friend has said that he has admitted one fact, I am fairly said, that we have to use that particular fuel card, which has been provided by the company itself to purchase the fuel. We cannot purchase from our own pocket.
Yes.
Neither the company, if we purchase to the fuel card, whatever the amount, it will automatically, because this is their card, this is not my card.
Yes.
So it is card of the company itself, informant's card. The moment I purchase 5 liters, it will be automatically reflected in their record. Then again, if I purchase 7 liters, 10 liters, 100 liters, it will automatically reflect. I cannot manipulate that amount and the amount I have purchased. So there cannot be manipulation on my side unless the Murthy manipulates after my delivery in the register. So Murthy is the kingpin and he is the person who has manipulated the record, their own FIR.
Okay.
So that is the case. But so even after Murthy resigned, he has admitted, even though the Murthy resigned, thereafter also they have given me the card to continue.
Your main case is that Anesh Kumar and Satinder Singh until has not been followed.
Yes.
35(3) has not been followed.
My lord.
That is your main case.
Yes.
I will examine the
And
case. then.
today is only 9 days, my lord. There are involvement of there may be involvement of the petrol pump authority also, because they are taking money. Whatever example I have given, my
Their
lord.
plea is very limited. If 35(3) has been followed,
My lord.
then prayer would be rejected.
My lord.
If it has not been followed, then it will be allowed. Let me go through.
Yes, my lord, there is my lord, apart from that, lordship, also lordship, while the lordship will go, definitely you'll see the paragraph 25 of the judgment also very important. 93 it is regarding, this is the landmark case.
Para?
This is the already my lord.
Fulchan.
Fulchan. This is the landmark judgment.
Para?
25. In the next page, lordship will find.
I will go through.
And Placitum B. Since Placitum B, my lord.
Page 96.
Page 96. Placitum B, my lord. Fulchan case. This is very important. it is regarding the income tax assessment, my lord. If there is a reason, my lord, that I have manipulated or I have evaded tax, then what is the requirement? Since the belief is that the income tax officer is sufficient for the reasons for forming the belief, it is not for the court to judge, but it is open to the assessor to establish that there in fact existed no belief or on the belief was not at all bona fide or one of the based on vague, irrelevant and non-specific information. To the limited extent, the court may look into the conclusion arrived by the income tax officer and the examinee whether there is any material available. This is very important. Whether there is any material available on record from which that requisite belief could be formed by the income tax officer, and further whether that material had any rational connection with the live link of the formation of the requisite belief, my lord. So similar to that, my lord, the Ernest Kumar, that belief and the reason, it has to be based on material, my lord. And then Lordship, my lord, page, there's one more judgment I'm relying on. The Lordship has already decided in one case in paragraph 13. Paragraph 13 of Lordship's own judgment, my lord.
I'll go through it.
Paragraph 13, Lordship has already decided paragraph 13, my lord. If there is no reasons in the forwarding, they are entitled for the benefit of it. My lord, apart from point, I have shown that the checklist, there is no reasons as directed.
Mr. A. M. Bora, London. Senior Counsel assisted by Mr. V. A. Chaudhary, Learned Counsel for the petitioner. Also had Mr. K. K. Parashar, Learned Additional Public Prosecutor. List this case for delivery of orders on Monday. Monday is 1st of September.
Obliged.
Give the case diary to me.
Absolutely.
Obliged.
So separate file would be separate file one.
Obliged.
Yes.
The case diary I have written.
If case diary is there,
Yes, case diary I have received.
then we can finally dispose of this case.
But if,
Will you file affidavit in opposition?
in fact, Lordship yesterday wanted to see the 183 statement. The statement is here. And two, I have also seen.
You have gone through the case diary.
I have seen.
Apart from the statement of
Apart from
that
the-
girl,
Apart from the.
any
183,
other witness has
two witnesses are there.
have implicated.
Yes. Two witnesses are there. And just wait.
Lordship, may I suggest something? Like I had indicated yesterday, Your Lordship, we are being led by Mr. Chaudhary. If this matter can be fixed on Monday, Your Lordship may peruse the diary and appropriate orders may be passed, Your Lordship. That's my humble request.
Mr. Hassan, will you be filing affidavit in opposition? No. Whether state would be filing or your oral submission is a,
In fact, Lordship wanted to see the case diary. and
no, I'll see today, but
Lordship, the.
but
Lordship,
we can dispose it of. Respondent number 3 need not to be implicated in his personal capacity as he is the
Your Lordship, another question, if I may. Your Lordship, in my view, respondent number 4 would have to file his reply because even in yesterday's order, Your Lordship, he made a mention of a complaint which allegedly is filed.
no, that is the discretion. If from the record, they can make submissions without,
in fact, we are on prima facie case.
no,
If-
no.
If Lordship,
No,
if Lordship, the.
what I am suggesting,
Lordship,
when their writ petition is before me, for what grounds they are seeking quashing, everything is before me. The case diary is before me.
yes. To buy-
Only the requirement is to give you an option to file affidavit. If you waive that option, I can dispose of this case finally instead of
Lordship has issued notice
that I will tackle.
that Lordship respondent number 2 has to be served, respondent number 3 Lordship, IO, in his personal capacity, Lordship. That notice Lordship has already issued yesterday, Lordship. So now without serving the respondent number 3, the matter cannot be heard finally, Lordship. And in personal capacity, one learned friend cannot accept, Lordship. That is why the final disposal, Lordship, come, Lordship. Lordship is already issued notice yesterday for 3 weeks.
On the basis of records, I am placing the case there before Lordship. And on the basis of records, Lordship will consider if material is there. If material is there, Lordship will accordingly consider that. Because our main case is that there are materials, investigation is required, and there is no. They said that there is no material, entire FIR is a fraud, is prevalent, and therefore taking cue of that, they said that it is to be passed. We said that there are materials, I have flagged out. Lordship will see, and on the basis of the records, Lordship will accordingly.
May I suggest something?
Lordship, another aspect is that Lordship.
And I'm
Lordship
also.
proposed that the respondent has written to.
Yes, what will happen to notice to respondent number 3?
I am placing
Your
reliance.
Lordship, may I suggest something? The incident allegedly has occurred on the 8th of August between 12:30 to 1:30 p.m. The witnesses in 294, which we have impugned before your Lordship,
With the file board of them. No, are you ready to make your final submission?
my lords may keep it on Monday, but on instructions, I'm making this request that my lords, the state has produced the case diary for 294. My lords, it is imperative that 293 case diary is also produced. I'll explain the reason why, your lordships. Because the incident is of the 8th of August, out of which 2 FIRs are filed. One is filed by the petitioner, one is filed by the respondent number 4. They are 2 different versions, your
The
lordship.
accusation against you is only under Prevention of SC and ST Atrocities Act.
I agree, your lordship.
And the accusation against that lady is
Is of cheating.
cheating. That is not under the that may be your ground that this is a counter blast.
That's correct, your lordship, which is why I am suggesting, I'll leave it to your lordship. What I am suggesting is because the witnesses in 293, the people who are present in the premises between 12:30 to 1:30, when this incident occurred, for which there are 2 different versions, they are the same people.
You choose a date in the next week when this matter can be finally heard. And what will happen to the notice issued already to respondent number 3?
But for 1 and 2, we are here. Lordship has directed us to produce the case diary. I have produced. And the Lordship here, I am placing reliance on 3 decisions. It says that Lordship's interference for quashing is only required if they can show that there is a prima facie case. I am placing reliance. I'm giving copy to the Lordship. Since the records are before Lordship, the law is very clear. Lordship may decide the matter. Otherwise, otherwise, whatever they are submitting, Lord, that as regard.
We'll place the judgments, your lordship. The learned senior counsel will lead us on the next week. My lord may fix a date in that case.
Suggested date.
But the object of the act will not remain. The way in which they are stretching it with their FIR, ultimately there is nothing, but Lordship will only see the record. If there is material, then the investigation will go, and they are prepared for.
No, I have not put any halt on investigation. Investigation is still continuing.
That's correct.
There is no stay on investigation.
But their basic plea in this case is that the entire the seat doesn't belong to SC. That is what they want to say now. That, and with that plea only they have come.
That can be found out during investigation.
But in fact, that has to be in the investigation, and Lordship may kindly see the purpose of the act. The basic object of the act is that the atrocities should not against the particular class SC, ST. That and that with that object, my lord, that whether there is offense under section 3(1)R is there or not. That much lordship will see. The record is very much clear. What more is required? In my respectful submission, my lord, going by the records, my lord, this can be very well decided.
Disposed of.
Yes, my lord.
Mr. What is your name?
C. Garg.
When can you?
Your lordships may have it either on 4th or 5th. Because I have been instructed that Mr. Chaudhary is available on 4th or 5th.
4th for final hearing.
5th, your lordship.
5th for final hearing.
Well, it's still then interim to be continued.
In fact, the lordship that compromise, that apology, the victim has written to the police that it was under pressure. It is also on record, lordship. It is also on record, lordship. Everything is in the CD, lordship. The protection should not be continued.
Whether leniency as has been prayed by my learned friend, he deserves that leniency or not. That lordship will consider.
That I will consider.
That lordship will consider. That
Your
leniency
lordship
should not
will
be
hear
shown.
us finally on
Because
Friday.
it's a-
I am only
it's a-
saying that protect us till Friday. Your lordship will hear us on
Now
Friday.
from Monday, he went up to Friday. That is what, my lord, we are objecting yesterday.
You
That this type
Go
of.
go through the order
True.
after the reference.
The leniency should not be shown, my lord.
Because
Because-
my only request is,
Otherwise,
no useful purpose would be served if my custody is taken today. Let this honorable court hear the matter on Friday. Let the learned senior counsel assess this court. Let my learned friends make their submissions. Then this court can pass a reasoned order. Your lordship.
Okay, I'll pass orders in chamber. But tentatively for final disposal on Friday. Regarding interim prayer, I will go through the case diary and pass order.
yes.
Because my
My-
request would
my-
be to just continue the
Okay, I have heard.
oblige, your lordship.
My lord, there is an,
Lordship.
my lord, there is an item 45. It has been long pending. My lord, can it be fixed on Tuesday, my lord? It has been long pending, my lord. Item number 45. I was under impression that it will reach, my lord.
You all may miss reference if you.
Absolutely. Item 45 next Tuesday, my lord, only to that extent. 44 and 45 are tagged together.
अपनी handle दे.
Lordship, my-
Pray before registry. Let the registry give dates.
My lord, registry will, because already.
No, I have I'll speak to joint registrar bench. Whatever is left over, you go to the registry and pray before that.